All protocol observed. Good morning, members of the Uganda Law Society who are online. I'm Isaac Atkunda, the Honorary Secretary of the Uganda Law Society, and I welcome you to the Tax Symposium, which is part of the continuing legal education. First of all, I want to thank Uganda Revenue Authority for hosting us and facilitating this symposium. I also want to thank our members and other participants who have chosen also facilitate this symposium. As Uganda Law Society, we always have CLEs as a way of adding to professional development of our members. And we always encourage members to attend these very informative and educational symposiums. So if anyone is missing, you are really going to miss a lot, because when I look at the topics to be covered in the coming 2 days, really, if you miss, you'd be missing what is so important, because tax is part of our daily life. We all pay taxes, our clients pay taxes. So having tax knowledge is very, very relevant for every advocate. Now, if you have a friend who hasn't joined yet, please inform that friend to join. Finally, as Uganda Law Society, we are grateful to the organizers of this symposium, and we look forward to having a meaningful and resourceful discussion. I thank you once again, and nice deliberations. Thank you.
Thank you, Isaac, for those wonderful opening remarks. Yeah, indeed, we are proud of the ULS organizing such events, because the members are able to acquire knowledge, and specifically for this, a tax symposium also gives us an opportunity to interact. So the program for the 2 days will be packed, but to get a head start, today I have the honor and opportunity. I'm going to introduce to you one of the key practitioners in our tax practice, Mr. Bruce Musinguzi. He's a partner and he co-heads the tax practice at Kampala Associated Advocates, KAA. He's going to be taking us through the avenues of disputing tax disputes through the Tax Appeals Tribunal. Mr. Bruce Musinguzi is well accomplished. He has a master's in international taxation from Georgetown University, and he has practice in the US with PwC and then JP Morgan. And he has really been involved in most of the cases that have been argued in the tax sphere, even the process of amending and advisory. So without further ado, Bruce, over to you. I'm going to request you to come through and you kindly take us through your topic. Thank you.
Thank you, Tony, for those kind remarks. I hope I'm loud and clear from your side, Tony. Can you hear me loud and clear?
We can hear you loud and clear.
Okay, thank you. My presentation today is about litigating tax disputes before the Tax Appeals Tribunal. Like Tony rightly mentions, we are currently representing a number of clients in the Tax Appeals Tribunal. And the purpose of today is just to share our experience using both decided cases and relevant legislation, so that we can have a discussion on understanding what are the challenges that we face as tax practitioners, what are the improvements that have been done, and what things do we believe should be improved going forward. For those colleagues who are joining us and who might not have a tax background, the way a tax dispute is commenced in Uganda's jurisdiction is first by receiving an assessment. Now, there are various types of assessment that are normally issued in our tax laws. We have self-assessment, default assessment, additional assessment, and advanced assessments. Now, once an assessment has been issued, the next process is for you or your client to object to that assessment. The objection is done in two forms. It is either done online, or in some instances, because you're giving a lot of information, some clients would also prefer to write to the URA formally and send them the basis of the objection. The online objection is very limiting, so it doesn't allow our clients to fully express their points. And as a result, they would always prefer that they go ahead and give some written brief or submission regarding the reasons for their objection. Now, a particular interest for us as tax practitioners, and this is something we as lawyers have to engage our clients at an early stage, is that when you look at the Tax Procedure Code Act, if you look at Section 24(2), it is very clear that once you have an assessment and you're objecting to it, you should ensure that you give the Revenue Authority sufficient evidence and information to enable them make an objection decision. One of the things that we are always faced with as tax practitioners is that many times we find that the assessment that has been lodged onto the system is that summarized assessment, which is about 3 sentences, the online assessment. However, the client has not gone ahead to provide reasons for the objection in a more detailed submission. Now, the problem with that is that our understanding of Section 24(2) is that limits you when you go before the tribunal, because remember that the URA sits as a quasi-judicial body. So they have the power to make a decision. Now, in order for them to make a decision, it is very important that, one, we give them all the information that they need, but 2, that we give them all the evidence that they need. We notice that many times what actually happens is that you have that summarized submission, but no attachments are put. The problem with that is that then we fall into the trap of URA coming back to us for more information, which ends up delaying the process of actually reviewing these matters. More importantly, however, is that when you then go to the tribunal, because some of those documents were never given to the URA at objection stage, they have the ability to object to them. And at times, you find that that delays our scheduling process. If we give the URA all of that information, it would make our scheduling process much easier. It would make the process of getting the joint file bundle more time limiting, because what is happening is that the documents that I am using have already been shared with the URA. So after you have lodged your objection, and maybe just before I go into the process of lodging the objection, one of the issues that we have always faced with clients is that as soon as an assessment is issued, especially when the assessments are of huge amounts, the client always insists that we need to run to the Tax Appeals Tribunal and lodge our applications. The problem with that is twofold. One is that the Tax Appeals Tribunal has taken the view that until the objection process is completed, then you have no jurisdiction to appear before them. Of course, I know some of you tax practitioners have always argued Section 16 of the Tax Appeals Tribunal Act, and your argument has always been that when you look at that provision there, it's talking about the taxation decision. If you look at the definition of the taxation decision in the Tax Appeals Tribunal Act, our argument has then gone further to say that it includes an assessment. In other words, once there is an assessment, I should be able to go to the tribunal. However, a number of cases that the tribunal has actually decided upon have said otherwise, and what they have insisted upon is that you need to exhaust this entire objection process. And what do they mean by exhausting the objection process? Is that once the assessment is done, do the objection, get the objection decision, then you can appeal to the Tax Appeals Tribunal. Of course, we are all mindful of the fact that under Section 25 of the Tax Procedure Code Act, you have the right to appeal to the Tax Appeals Tribunal only against the objection decision. Then there's the other point there that the Tax Procedure Code Act never amended the Tax Appeals Tribunal Act. In other words, the provisions in the Tax Appeals Tribunal Act still stand to the extent of jurisdiction of the Tax Appeals Tribunal, and therefore you have the right to continue with your process before them without necessarily waiting for you to get the what? To get the objection decision. So it still remains to be an area that has caused a lot of confusion, but in many instances, the tribunal has taken the stand that they will only accept an objection, they will only accept an application which arises from an objection decision. So you then lodge your objection to the URA, and the URA is given timelines within which to issue an objection decision. The point there also is that if you look at Section 24(9) of the Tax Procedure Code Act, is that it seems to give the URA leeway to extend time for purposes of concluding the objection decision on the basis that they are going to reach a settlement of the objection decision. The challenge that we have always faced with that is that many times when clients are faced in such situation where the URA exceeds the time, the 90 days for giving you the objection decision, some clients want to rush and do an election. However, the URA normally posts on the portals that they are going to extend time for them to do the review. Sometimes our clients miss that, and because of that, we are then rushed into doing elections, which unfortunately for us are then rejected. So from our side as practitioners, we always encourage our clients to look out at the portal to ensure URA has not extended time under section 24(9). Of course, some of you are going to say, but this is such an unfair provision, because the way it looks now is that it gives the URA the right to actually extend time without necessarily consulting the taxpayer. Well, unfortunately for us, that is the current provision that we have, and that's the one we're going to base on. Now, still on the objection decision, is that you will realize that URA has moved away from the process where they used to give us a submission detailing the reasons for the objection. Now, what you normally get is just a very small 3-sentence submission where they just say objection disallowed for lack of sufficient evidence, or objection disallowed because you failed to comply with provision X, Y, and Z. In the past, what used to actually happen is that you get a more detailed objection decision. What that would do for you is that when you went before the tribunal, you then had the ability to limit URA to their objection decision. Because you're moving from URA to the Tax Appeals Tribunal. Remember, Tax Appeals Tribunal is sitting in as a review body of the URA. They should be able to review a decision that the URA has made. And that decision there is the objection decision. That decision there should have reasons and justification for those reasons. If that is not there, then it makes it a little complicated for all of us as practitioners. And we all have this problem on what am I actually seeking a review against. Now, turning back to the assessment, I noticed that lately we have just been getting those online assessments without necessarily getting that management letter. The purpose of the management letter, like is with the detailed objection decision, is that they are supposed to guide you and your clients in order for you to understand the reason for the URA's decision. Why is the client being assessed? Or why is the objection being rejected? If you have that detailed submission, that enables you to articulate your points before the tribunal much better. So once the objection decision has been made, the next course of action for you to take as a practitioner is to go before the tribunal. Now, lately we have been seeing a number of cases where some practitioners have insisted on going before the high courts. Of course, we know that following the decision in Rabo Enterprises, the only body that has jurisdiction for tax disputes is the Tax Appeals Tribunal. In addition to that, the question that has always popped up is then, what disputes can I take to the tribunal and what can I take to the high courts? Briefly on that point there, the disputes that could go to the tribunal are disputes that are arising from a taxation decision. However, disputes that do not arise from a taxation decision, I'll give you an example. If it regards the revocation of a private letter ruling, or you're challenging a practice note, those are not decisions which the tribunal would have jurisdiction. And that's why you will notice that when Sadolin was being litigated, Sadolin went to the High Court and did not commence from the Tax Appeals Tribunal. However, all other disputes have to commence in the Tax Appeals Tribunal. Now, the process of going to the Tax Appeals Tribunal has also been a little challenging when it comes to the issue of 30%. The challenge with the 30% is that many times it's based on the objection decision. Like I've already noted, the objection decision in many instances is based on just that one-line summary where the URA is upholding its assessment. I'll give you an example. If your client had an assessment worth 300 billion and you have to pay 30% of the amount of tax that has been assessed before you lodge your application, there's no client in this country who is going to raise 90 billion shillings just in a split second. So there's always been an issue of 30%. And many times we have appealed to the tax appeals tribunal to give us timelines for payment of the 30%. As you will notice in the Coca-Cola decision against URA, the tribunal did give timelines for them to pay the 30%. In other instances, what the tribunal has said, like happened in the Samona case, is that you can actually apply for an extension of time for payment of the 30%, and that is covered under Section 28(1) of the TPCA. The purpose for all of this is to enable our clientele to be able to have a valid application before the tribunal. The reason that we raise these points is that many times when you go to the tribunal, one, without paying the 30%, or two, when you're out of time, then it's highly likely that your matter is going to be dismissed. The tribunal has had a hard stance on people who are filing their applications out of time, especially outside the 30 days, is that many times those applications are actually dismissed. In addition to that, for people who have failed to pay the 30%, you will also have the application dismissed if it hasn't actually been paid. So as practitioners, one of the things that we always encourage our clientele to do is to make sure that that 30% has actually been paid before you go to the tax appeals tribunal. Now, the process of the tax appeals tribunal is that we commence with an application. The application is a standard format application, which is always provided by a tribunal. After you file your application, the URA is given 30 days within which to file their response, which is the statement of reasons against your application. Then you move for the process of scheduling. Now, the reason scheduling is very important for us is that in the tribunal, as a practitioner, what we realize is that the tax appeals tribunal prefers to go with a joint scheduling memorandum. They are very highly unlikely to accept a party-to-party scheduling or a party-to-party trial bundle. The reason for that, that Chairman has explained several times in the past, is that he expects that at the point when you come to the tribunal, all of the documentation you intend to rely on in the tribunal should have been shared with the URA before you came to the tribunal. Remember when we commenced our discussion today, we had informed you that you have to ensure, one, that you share all of the documentation with the URA under Section 24(2). So what the chairman is saying is that, and what the tribunal is actually saying, is that when you come before the tribunal, by that stage, URA has already reviewed this documentation, and therefore there shouldn't be a challenge to having a joint trial bundle. Of course, I know as practitioners, we always have challenges with having these trial bundles filed. There's a lot of push and pull, but that is the process that the tribunal has taken. Now, once your documentation is all before the tribunal, then you commence the hearing. The tribunal takes the process of having an informal hearing process, unlike the High Court, which is a formal process. With the tribunal, it's a little informal. However, the rules of evidence and the civil procedure rules will still apply. In other words, they will not accept hearsay evidence. They will not accept documents that are not signed. Particularly for the tribunal, if a document is not signed, it doesn't indicate an author, doesn't have a date, it is highly unlikely that that documentation will be accepted. So from our side as practitioners, one of the things that we have always encouraged our clientele and colleagues to do is make sure that all of our trial bundles, the documents that we are submitting before the tribunal, should be signed and should be dated, and also the authors of those documentations should be known. Now, once that process is done, then you go into the issues of calling evidence, and then, of course, finally, you go into the issues of getting a judgment. However, some of the points that we think we also need to discuss two-founded. One is that we want to touch back on the issue of 30%. I can see a lot of the pop-ups are coming and asking on the 30%. The issue of 30%, yes, we understand is the QLX decision of the Constitutional Court, which seem to give a liberal approach to the 30%, especially when you're challenging an assessment on issues of legality and not on quantum. The tribunal, we haven't yet seen a case so far, where the tribunal has agreed that somebody shouldn't pay 30%. We are yet to see one. However, we have seen cases in which I think there's a recent decision of 2 days back where Her Lordship Justice Abinyo allowed somebody's application to stand even when they had paid 30% after the application had actually been dismissed. So it seems that going forward, there seems to be a liberal approach on how the issue of 30% is being dealt with. Many times we have had issues where there's a debate on, for instance, if it is an additional assessment. Do I pay 30% if I've already agreed to pay a portion of the assessment that exceeds the 30%? Haven't I complied with the provisions of Section 17 in that instance? Or do I still have to pay 30% of the disputed amount? Of course, the Nile Brewery's case comes into play in that instance where the court was saying no, that if it is a matter of an additional assessment, you still have to pay the 30% of the tax in dispute, despite the fact that the tax not disputed is much higher than the tax in dispute. So when it comes to issues of 30%, it seems that there the stance has already been made, and you have to pay 30% of whatever amount is going to the tribunal. The other point that we felt is important for us as practitioners is the issue of the days within which to go to the tribunal, timelines. The importance of timelines is that many times you realize after the 30 days, some of our clients still want to continue engaging with the revenue authority. The problem that we have had with these engagements with the revenue authority is that many times, one, they are not documented, and even when they are documented, the revenue authority maintains that all it is doing is maintaining its assessment even after a lengthy period of negotiations with them. Therefore, what we always advise our clientele is that as soon as the objection decision is raised, you're much safer filing your application within the 30 days, but that doesn't stop you from continuing to have discussions with the revenue authority. The other point that has always come up is that after the payment of 30% of the tax, then what happens? Do I continue to incur interest on that amount of money? The Airtel versus the Uganda Revenue Authority has come in handy, especially for many of us practitioners. Our clients have felt that if I pay the 30%, then why is there an interest and penalty that is still accruing? And to that extent, we have had at least some jurisprudence that says, no, you don't actually need to continue paying any interest and penalty on that amount of money. So as a practitioner, where we stand so far, given our experience in going before the tribunal, we think the process is thus far very helpful. We think the tribunal is doing its job well. Of course, some areas can be improved, which would include allowing parties to file single trial bundles, because that takes a lot of time, or even allowing parties during scheduling. If we don't agree on facts, then we shouldn't actually spend a lot of time trying to force the other side to agree to some of the facts that we think should be included in our GSMs. So that is our experience in a nutshell. And I think our time is lapsed with the 30 minutes. So thank you very much. If you have any questions, we are happy to respond to them. Thank you. Over to you, Sean.
Thank you. Thank you, Bruce, for the wonderful presentation. You've taken the members through how the disputes, as far as tax are concerned, start from objections, then to the tax appeals tribunal. You've given us the advantages of a detailed objection as far as the minimum one is concerned. You've analyzed issues of 30%, timelines, and so on. But in the chat, we had a few areas which you touched on, but for clarity, we could see if at all they have been covered. There is someone called Jilfine Mokwero Omwenge. He or she they were stating that tax transactions are mostly tripartite. The TPC Act needs to be amended to allow for extension of time while handling matters with URA. He goes on to say that it is only 90 days to handle the assessment, yet it is costly to lose an assessment because an advocate could not get info to defend at the URA level. We need to allow for an extension of time under section 24.9 of the TPCA. Maybe if you could come in to address these concerns that he raises.
Yes, Tony, I think I agree with the participant on issues of time, especially when it comes to the objection stage. Your client is served with an assessment. Of course, the process of leading up to the assessment is not that they just wake up one morning and issue you with an assessment. There has been a whole process of an audit, and you've had a lot of meetings between yourself and the URA. You've been agreeing on some of these things. Then finally, you're given the assessment. The challenge that we face as practitioners is that many times the audit period is conducted by accountants. At the point of the assessment, some clients actually approach us. Many of them don't. But those who approach us, you realize that between the period of the assessment and the period of the objection, that 45-day window that you're given, in order for you to file your response, you realize it is such a short time. And I agree with the participant that if you look at section 24.9 on the other hand, is that 24.9 gives such a lengthy period of time for the URA, first of all, to make an objection decision, but even then, they also have the ability to extend time for them to come back to you with the objection decision. So they can exceed the 90 days. The days that are given for objection, I think I agree, should be extended because, first of all, the amounts involved are so huge, the issues involved are so intricate, but also it takes a deeper understanding of some of those issues before you can make a detailed response to the URA. So I agree, the issue of time needs to be thought out and needs to be considered in some of the amendments for purposes of the taxpayer.
Yeah, thanks for that. And I think it's something we can explore during the amendment process. But although, just like you pointed out, Bruce, time can be extended when it comes to both the taxpayer can request for an extension of time. Then also URA is allowed under the law. If at all it requests for additional information, then the timelines begin to run again within the 90 days period to make a decision. But still, we look forward to that proposal because tax should be collected on merit. If there's still time, then it can be addressed. Then also, when it comes to mediation, the other aspect we have seen is that when a matter is mediated, it's not unusual for the mediator to allow parties to exchange information, to try to reconcile the tax or to agree on what is actually in dispute. So if that timeline provision is handled, then the mediations will become easier and we'll see a more resolution of disputes. Then another question, we have my senior, someone very historical, Mr. Samuel Kahima, Uncle Kahima. He has extensive knowledge when it comes to tax matters, having worked for a very greater period of time with Uganda Revenue Authority. So he has concerns. One of them was the authority on 30% Court of Appeal stayed, the fuel X issue. Bruce, since you're the panelist, you could come in handy on that.
We haven't yet seen a stay on that decision. I haven't, at least to the best of our knowledge, we haven't seen any stay on that. So I think currently it's still good law. It hasn't been stayed. No, to the best of our knowledge, it hasn't.
Thanks for that, Bruce. Although there is another decision of UPMAC, Uganda Projects Implementation. The argument is that it also having started from the Court of Appeal, sitting as a constitutional court and gone to the Supreme Court, whether or not fuel X is any other way, according to stare decisis and precedents, if the tribunal is to follow a decision and respect the principle, it may be inclined to follow the Supreme Court decision of UPMAC, irrespective of the Court of Appeal decision in FuelX. But then it raises valid concerns, because if it's purely a point of law, practically, why would 30% be required when there is none? Yeah, so it's an area we need to debate. Other countries are taking the right approach, like Kenya, which tried to push for a 50% deposit, but they failed. Then others tried to open it up as a human rights issue, but it's something we'll explore. Then I'm going chronologically. Deus Mugabe from Shonubi, also a tax practitioner, he agrees with your view that when it comes to the trial bundle at scheduling, that parties should be allowed to file their own trial bundles, which I think is okay from a practitioner.
Maybe I can just jump in before you leave, Tony. And I think this is one of those areas where we as applicants counsel always have a challenge. Because, of course, looking at it from the side of the tribunal, they are like Ali has mentioned, they're coming from section 24.2 and saying, look here, these are documents you should have given the URA. So there shouldn't be a challenge to them. However, if at objection decision stage, at tribunal stage, there's further documentation that we think could assist the tribunal in making a decision, then maybe that's where we should be allowed to file our own separate trial bundles without necessarily having to insist on the joint, because the joint trial bundles have caused a lot of delays. We keep on adjourning until we get a joint trial bundle. Yet if we moved by having our own party trial bundles, it probably will make our lives easier. So I agree with you on that as well.
Thank you. And then for just a sneak shot, tomorrow we might have the opportunity of the chairman, Tax Appeals Tribunal, addressing us. So maybe we could seek clarity on his view. Then still another question from Mr. Samuel Kahima. He requests you, Bruce, to address the question of assessments and timelines as determined in the game case. Would it be sub judice? But briefly, from what I get, there was a case of game discount, which Bruce, I think you're aware of, debated. The Tax Appeals Tribunal decided the issue, but there were issues of timelines. As far as the East African Community Customs Management Act is concerned, the argument of game, the applicant, was that by URA taking a lot of time before responding to its objection, automatically, by the wording of the IACMA, there was a deeming that URA had made a ruling in favor of the taxpayer. Then also the argument of URA was, which argument it raised first in the case was that at the time game went to the Tax Appeals Tribunal, from the date of the decision, from the date of the assessment, there was lapse of time. So the TAT determined the URA point of law first and held that game was out of time. But the argument of game was that even if it was out of time, there was a lapse between the decisions. So the matter went to Justice Mubiro at High Court Commercial, who explained deeming and resolved that whereas expressly it's not provided for, that as per the domestic, there is an election bit when it comes to the Tax Procedure Code Act. It says that for deeming, you must also take a step to write and you claim. But maybe if you could address the question of Mr. Samuel Kahima on the questions of assessments and timelines as far as game is concerned. Over to you, Bruce.
Okay, thanks, Tony. I think you've ably handled the issue of game. And it's also a problem that we always have as practitioners. Once the assessment is issued and then you make your objection, you realize that many times the URA might not respond within the 90 days that are provided for in the TPCA. The question then happens is that what do I do after the 90 days? One of the things that is important for us to note is that many times, towards the end of the 90th day, URA does one of two issues. Either it gives you that objection decision that is a two-liner, saying that the objection has been disallowed because of lack of sufficient information, or they proceed under section 24.9 and say that they are seeking to extend time. Because these are sent on the portals of our clients, some of them actually miss-send. But let's imagine that these two were not sent. One, the URA hasn't responded to the objection, but two, it hasn't sought for an extension of time. The next stage in that is, how do I make my election? I agree with you, Tony. I think what the judge is trying to say, from my understanding of gaming stores, is that it's not for you to fold your hands and say that, okay, because you've gone quiet, then it is deemed that you have agreed with me. You have to take the proactive step as an advocate or as our client. They should write and tell URA that on the basis of your not responding to me in time, I am deeming that this my objection has been accepted, and my election is that you have decided not to continue to collect this tax. The challenge happens is that many times when the URA doesn't respond, our clients go quiet, we as advocates go quiet, and we think that that amounts to an election. Our understanding of the tax appeals tribunal of the TPCA and the IACMA is that, and also the decision of Justice Mobiru, you have to take an additional step, and that additional step is for you to make a written response saying that you've elected, and on the basis of your election, you're deeming that your objection has been accepted. That's what it is.
Thank you, Bruce. We still have you here to capture up. Deus has also concerns. He raises a pertinent issue, which I think you're more competent to handle, being that you represent mostly tax collectors. Deus argues that, in his view, that why doesn't the taxpayer also require 90 days within which to prepare their objection, since the tax collector URA is also given 90 days to make a decision. And the concern is that URA has also spent some time raising the assessment. I think that handles the issue of parity, but maybe you can address that.
Yes, I think for me, on issues of timelines, I think the timelines that are given to the URA should also be given to the taxpayer. Our view is that there are 45 days that are given to the taxpayer are really short. By the time, and depending on the nature of the assessment you're dealing with, if you're dealing with a transfer pricing assessment, I mean, it involves a lot. It's not just a law, there's economics involved, there's law involved, there's strategy involved. 45 days is not sufficient. I think a taxpayer should genuinely be given 90 days. But in addition to that, I think a taxpayer should also be allowed to extend the time. I know the taxpayer can apply to the URA for extension of time, but if you look at section 24.9, where URA just extends time, I think that's too, like you rightly mentioned in Tony, the issue of parity, whatever applies to URA should also apply to the taxpayer, so that we have sufficient time to make our responses. And probably that explains why many times our objections are very limited and don't provide sufficient information. If we had the time, I imagine would give more detailed objections. So I agree with Deus that the time needs to be thought out and extended. I do agree.
Thank you. Then in respect to game, Deus also raises an issue expressly saying that the IACMA, unlike the TPCA, the East African Community Customs Management Act, unlike the Tax Procedure Code Act, the IACMA expressly has no provision for an election, but the TPCA has an election, and that was his issue with the game case. But then also, I think he agrees with the Kenyan, there's a Kenyan authority on the IACMA that is to the effect that you don't make a decision as the Commissioner Customs, there is already deeming. But Justice Mobiru of the Commercial Court, High Court, distinguished it and gave another interpretation to deeming, which I think maybe we can comment on. So Bruce, I'm going to advise that maybe you go through the comments yourself and you highlight them because most of them agree with you, and maybe you can pick onto them. Over to you, Bruce.
Okay, maybe I just wanted to comment on that whole issue of the EACMA. Because we all understand that the EACMA is a result of integration. One of the things that we are facing, and we have had discussions both with you, Deus, and a couple of other practitioners, is that you can't have a situation where a Kenyan court is saying you can deem, and the Ugandan court is saying you cannot deem. Then the issue of integration is being affected. I think we have to reach a point where we all agree that if one partner state has made a decision regarding the EACMA, it should be binding on all other partner states, depending on the level where it is made. If the decision in Kenya, which I have read, is a high court decision, then of course it's persuasive, but it should be used by our judges here so that we don't have situations where one court is saying you can deem, another court is saying you cannot deem. The bigger challenge with that, if you get out of the procedural issues, is that then you're going to have issues where, for instance, one court is saying you can tax this product, another court is saying you cannot tax this product. That makes integration lose meaning. Because in that instance, what you're going to have, you're going to start having two contradicting jurisprudence. Kenya is saying tax the product, Uganda is saying you cannot tax the product. What happens? What do I do at the border? So I think as a way forward, one of the things that we need to think about deeply as tax practitioners is that isn't it time that some of the disputes, especially disputes that arise out of the EACMA and the CET, are disputes which are taken maybe to the East African Court of Justice, or we need to have an East African Tax Appeals Tribunal, which only deals with those issues, so that we can have parity and uniformity in integration. That would be my comment. For the other comments, I think because of time, I can respond to them online. I'll just type out all of my responses to them if it's still with you.
Okay, thanks a lot, Bruce, for that wonderful presentation. It was lively, as you can see through the comments. And just like you stated, you will be responding to them through the chats. Well, colleagues, our next item on the agenda, we have an opportunity as a country, Uganda, to have Professor Keith Engels. Professor Keith Engels is from the South Africa Institute of Taxation, but I'm going to call upon Mr. Edward Balaba to come in at this juncture online and then introduce Professor Keith Engels. Edward, are you available and you come through? Thank you. Edward, your audio. Unmute.
Can you hear me?
And hear you loud and clear.
I'm to introduce Professor Keith. Prof, you're welcome. And thank you for honoring us with your presence. I can never do justice to the CV of Professor. He's practiced for over 30, 40 years. He's practiced across continents, the US, across Africa. He's been in tax academia. He's been in tax administration with the South African Revenue Authority. He's done tax consultancy with a Big Four audit firm. He's literally done everything tax. And we are honored, Prof. And he's also extremely passionate about training and sharing tax knowledge. So one of the areas for which he's passionate about is tax treaties. And Prof, we have the honor to have you take us through your presentation on tax treaties, double tax agreements. Thank you, Prof.
Thank you, Edward. Appreciate seeing you again. It's been a while. Not so long, just a couple of days ago, but still, great seeing you. And we'll hope to communicate further. Okay, I'm going to try to share the screen. Now, some things I can do more easily than others, but somehow the screen doesn't share with the thing. My subject today is double taxation agreements. Somebody's here to help me. I'm not sure if they can share easily. What are we seeing here? Now, it's open somewhere. Do you want me to open it? Okay, let's try. It's on the desktop. Do you want me to open it?
Yeah, can you open it and you will share?
Okay, let's see. We're gonna open it up. I need some help for these things. I can do a lot of things, but I cannot do IT. So that is a problem. Now I'm popping it open. Okay, is that not shared? All right, let's hope. Is it shared? Can you see it or no? Okay, we got it. Okay, great job. Thank you. It's wonderful to have good assistance. Okay, a few days ago, I was invited to talk about double tax treaties for the EAC. This is a variation of that presentation. I am talking mostly about Uganda today, so I'm going to make it much more specific than the last one. So if you saw the last one, hopefully this one is a bit different. Anyway, what we're focusing on is double tax treaties. One of the key elements to cross-border taxation is double tax treaties. But what I'm trying to do here is try to show you how it integrates with your domestic law. Because remember, when you look at the tax treaties, it sits on top of your domestic law. So you need to do all your domestic law things, and then there's a variation. And the focus here is mostly investment into Uganda, because that's probably a major focus for you more than investment outward. So when you look at double tax treaties, basically what we're talking about is two countries trying to allocate taxing rights between the two. So there's an investor country and an investee country. So it's either the British investing into you, Netherlands investing into you, maybe Mauritius, maybe South Africa. The question is, if they're investing into Uganda and Uganda's claiming a taxing right and the foreign country's claiming a tax right, you don't want double taxation. You want to make sure that there's one tax amount, not two, or it's balanced so that you're not paying double taxation. So if you look at all the agreements, they talk about double taxation was the main concern. And the concern about double taxation is if you're double taxing investment, then the investment won't come. So it's not supposed to be a giveaway. And what you'll see typically is there's a balance. Is it Uganda that's going to give their taxing rights up, or is it the foreign investor country? Then when you look at tax treaties themselves, there's also, besides double taxation, there's also a secondary purpose of preventing avoidance and evasion. And for really up till probably 2013 in the BEPS, I would say 95% of all effort was about double taxation. Increasingly, though, you've seen concerns about avoidance, that there have been multinationals and others who have worked out the international tax paradigm. And what they do is they find a low tax jurisdiction and they use the tax treaties as a way of reducing the tax globally down to zero. So things have moved, and you're seeing a lot of discussions in the OECD and elsewhere about how to make sure that there's no double non-taxation, there's no avoidance. And then the second element of a concern is about, well, who is going to tax? Because should it be the foreign investor country or should it be the investee country? So if you've got investors in there from China, from England, from the United States, the question is who's got the primary right to tax? And there's a conflict going on where both sides want the most tax. The problem is for the country, for the investment, is that if there's too much either way, you will see a discouraging of investment. And I think that's sort of been going on a little bit, that there's got to be some sensitivity there. But it's really about a balance. You've got to get the right balance at the end of the day. Now, when we look at tax treaties, they come out of the Vienna Convention. They're binding by virtue of that. Different countries have different ways of incorporating them into the law. The US has certain rules. They incorporate treaties into law via the Constitution, but they're on par with local law. So there's a last in time rule. Whatever comes last prevails. In Uganda, you have brought the DTAs into effect as if it was part of the Income Tax Act. And the DTAs are supposed to prevail in the case of inconsistency. But what we've seen recently in one of the cases, where you're seeing it sort of a last in time rule. So sometimes there's the battle of the treaty versus the other, how it focuses out. But a Target Well case said it's really the treaty. But there's another one, I'm not so sure if it goes along with that, Sapphire, which is a little later. Then there's the South African rules. The South African rules again incorporate treaty into domestic law, and they try to avoid a conflict. So as a general matter, the treaties will prevail. Now, the big thing about treaties is they're binding until they're revoked. So one country can always revoke with a notice period. The key thing is it's usually a political problem. So even though they can do it legally, politically, you don't want to be revoking treaties. But you have seen a little bit of this in South Africa, not in Africa. So for example, I think Senegal revoked its treaty with Mauritius. You're seeing Mauritius trying to negotiate the treaty with Kenya, and that's sort of in flux. You're seeing Uganda itself into a different view of things. So if you take a look at your treaty network in Uganda, you've got the United Kingdom, because that was your former colonializer, so to speak. And that treaty is an old one that's been around. You have a treaty with India, which is probably a major player in the area. So that makes a lot of sense. South Africa, you have a treaty with. You have a treaty also with Netherlands and Mauritius, which are probably a little bit more contentious. And then there are four other ones: Italy, Norway, Denmark, and Zambia. I'm not sure how much investment you get from Denmark and Norway. You do get a lot of international multilateral support. Zambia, maybe you're investing there. It's a little bit. And then there's Italy. So I would say that your main treaty partners, you have to look where your investment is. Then the EAC treaty, that was approved in 2010. So that's supposed to be a regional treaty. That was a bit of a discussion last time, but that's still waiting ratification by Tanzania. So you're waiting for that regional EAC at the treaty level, as you're trying to have it at the customs level, but you've got a holdout there. So really the key is Tanzania needs to come on board. And then Uganda announced in 2014 that they are not going to be entering into new treaties until a review. And I understand right now they are renegotiating the treaty with Netherlands. I'm sure they're doing the same with Mauritius. Now, the big thing that you have to watch for in treaties is this really an investor country or is this an intermediary? So if the United Kingdom is investing, it's typically entities that were born and bred in the United Kingdom. If it's South Africa investing directly, they were born and bred in South Africa. The problem is Mauritius and Netherlands, because especially Mauritius, because Mauritius doesn't really have a lot of homegrown countries. Most of those are coming through elsewhere. So for South Africa, they're not necessarily going to go directly into Uganda. They'll go into Mauritius and then go to Uganda. And that's where the issues are. The injection of Mauritius or a Netherlands, which is low tax jurisdiction. And as a low tax jurisdiction, people feel that they are gaming the system. And the problem is, how do you get rid of that gaming? And that's what a lot of the battle is all about. So just to note. By the way, I mean, I have no objection. I know we have questions toward the end, but if somebody does want to raise a Q&A in the middle or raise their hand on some point, happy to pick it up as we go. And that's just to note there. So I'll just try to keep an eye on that if I can. The system is being a little funny with me, so we'll keep an eye. Okay, anyway, just moving it up, and let's go down one. Down. The system seems to be stopping. Okay, here it is. Sorry, we'll go back one. There it is. Okay, so we have 9 in force. That's not a big network. South Africa's got a treaty network of 70. I guess just to close this as a policy matter, countries should have a treaty network where the bulk of its investors are. So really, I mean, for example, I know that China's there. So China would be a country you should have a treaty with. I believe probably the US is also there. You probably should have a treaty with them. So you should have a treaty with countries where you've got cross-border investment similar to cross-border trade. Unfortunately, sometimes when we do treaties, we do them for political reasons. President wants to sign a treaty with somebody because they like them. But a tax treaty doesn't really work unless there's really cross-border investment and there's really promise of cross-border investment. But just to do a treaty for the sake of the treaty doesn't make sense. Now, when you're looking at double taxation, you've really got three types of things to be involved. You've got to worry about double taxation, and the first usually is on residence. That's usually the typical battle that's going on. The second one is usually about source. And so at the moment, we'll start with residence. What you'll typically have is there a conflict? So if I'm from South Africa and I'm visiting Uganda for a long time, who am I the resident of? Am I a resident of South Africa or a resident of Uganda? Because Uganda may claim I'm a resident, or South Africa may claim I'm a resident. And if I'm a resident, residency taxation there are two forms of taxation that a country can claim. They can claim based on residency, or they can claim based on source. And if you're claiming based on residency, you'll find it's a wider taxation. I'll come back to that in a moment. So what happens if, both Uganda and South Africa claim that the person at issue is a resident of each of their countries under their domestic law? When that happens, Article 4 kicks in, and Article 4 will resolve that. The second battle is usually about residency and source, where what happens is South African invests in Uganda, their activities that are sourced in Uganda, but the person is still living in South Africa and working in South Africa. That's a residency source dispute. That's what the bulk of the treaty works toward, which is Articles 5 through 21 and 25 generally. We're talking about the OECD style treaty, but it's similar for the Ugandan treaties. And then dual source is when both are saying that the activity arose in their country. And as a general matter, you can only resolve that by competent authority or Article 9, but it's pretty rare. So you will see claims on source, dual claims. Certain countries have extended source notions, like India or Botswana, and that causes a lot of treaty confusion because treaties are not designed for both people saying the activity occurred in the same country. And that's where you'll see a lot of the multinationals complaining that two countries are claiming source jurisdiction because the treaties won't resolve it. And then, it's one thing to be taxed in one country, but you don't want to be taxed twice on the same thing for both. So treaties are really designed for categories 1 and 2. Here, there's one in the chat. I'll just take a notice. Okay, one point you mentioned. Okay, one point that you mentioned is you must ensure you have cross-border investments. Our investment to the U.S. is insignificant. There may be FDI from U.S. into Uganda. Without mutual investments, do we need a treaty? No, a treaty works if you have investment one way. It can be both, but if you've got U.S. people investing into South Africa or if you've got U.S. people investing into Uganda or you've got Chinese investing into Uganda, you have a problem because you've got to worry that China will tax them and Uganda. Similarly, if the U.S. So it's once you've got cross-border investment could be both ways or one way, but a treaty resolves it so that there's no double taxation. So I would argue that you should have a treaty with both because you've got Americans coming in and you've got Chinese coming in, and you want to make sure that they're not subject to double taxation. Otherwise, after a while, it's not worked out. Now, the way the Chinese typically do it is they do it with side agreements. Okay, I'm glad you agree. And that's where thanks for the question. So anyway, we go to this point I was making about residency and source. There's two kinds of jurisdiction. A country will say, you are my resident, therefore I'm going to tax you. Or the activity is there, the source, which is country specific. Now in South Africa, you have worldwide taxation for residents. So if you're a South African resident, you are taxed worldwide around the world for all of your activities around the world. Similarly, if you're an American or a European, that it's a worldwide tax system. What you will find in Africa, however, worldwide taxation really is not as strong, and they generally are pushing more for source and just source. So anyway, residency taxation is wide, source is country specific. Did the activity occur? Where did it occur? So one of the big battles is about services. If I'm in South Africa and I provide services to Uganda, but if the Ugandan pays me, typically you're going to have a source problem because the South African can say the service happened in South Africa because that's where it was rendered. But because the payment came from Uganda, they'll say it's sourced there. So the treaty is designed to resolve some of those issues, but there's a bit of a problem in that area that it's not being resolved. So generally what you'll see is a residency source conflict where South Africans will invest in Uganda. And if they do, what will happen is that source, if the activity happens there and it's respected, then what happens is the Ugandans tax it first, and then if there's a higher tax, South Africa will tax it second. So for instance, a South African company might go invest in Uganda. Uganda will claim the first right of taxation at 30%, and then South Africa will claim another right if they tax more. But typically, South Africa's rate is below the Ugandan rate, so it'll pass away. So again, just a little bit about residency versus source. Source is the first right of taxation, but it's narrower. It'll cover less. Residency is a secondary right, which covers more worldwide as a general matter. I'm not sure, you can clarify for me, but I don't think Uganda has worldwide taxation. And if it is, you certainly don't have CFC, which accompanies it, which is key element. So let's take a look, there's another one. Oh, okay. This is interesting. I've stated that Uganda sought to review its treaties. My question is, was it completed and should we expect reinstatement soon? I'm actually not sure. I mean, I've looked around. I don't know the Ugandan government that well. I know that all the agreements are in place. They're renegotiating with Mauritius, with Netherlands right now, but they don't seem eager to enter into new tax treaties. And I think that's where business should come in and say, look, there are some treaties that you should enter into. I think the US would enter into a treaty, and I think the Chinese would. Again, maybe the Chinese are working their way around it. As I said, I know that they've got big investments in oil in that space. Oh, you do have worldwide taxation for your residents. Thanks, Janet. So I wasn't sure about that. There is a worldwide taxation for residents, but they don't have CFC. So what that means is that if you've got a Ugandan company that invests directly into Zambia, it'll be subject to worldwide tax. But typically what Uganda will do, the Uganda company will do is set up a subsidiary, and then you won't have that anymore. So there is a worldwide tax there, but without CFC, it makes it quite narrow. But that's a good point. Okay. And we'll move on. Let's see if I can move it. System sticks again. Hold on. Okay. Okay, now there it is. It just sticks every once in a while. Okay, so the first thing is the tiebreaker. When it comes to the tiebreaker clause, it just depends how it's done. So if you're a foreign resident and a foreign person, you'll typically, there's this ordinarily resident test. Where am I going to retire? That's my home country. Or there's a days test. You spend more than half the days. That's the standard. And then US is citizenship and green card. So as a former American or as an American, I am subject to worldwide tax, and there is no relief from that. So you'll find the US rules are very sticky in that regard. But generally, it's an ordinarily residence test if you deal with the UK, or a days test. If you look at Uganda, you guys have 3 tests. You have a permanent home, which is a lot like the ordinarily home test. You've got the 183-day test. So if you're more than half the year in the country, you're a resident. Or if you've got a 122 average over the current year over 3 years, you'll claim it. And then there is the government employees who are posted abroad. So you've got your 3 tests. So if it's a South African is an ordinarily resident test, or they spend a 183-day test. So a South African one is quite simple. What will happen is, let's say you have a South African resident, he spends say 130 days in Uganda, part of the year, and he's been doing that for 3 years in a row. Well, the Ugandans will claim he's a resident, and because he's based in South Africa and he's mostly going back there, South Africa will claim it. What happens then? You look at each law and they have a dual claim. Well, then what you have is a series of tiebreakers. And the tiebreaker clause looks to, like, where was your permanent home? Where's your personal contacts? Like, is my family back in South Africa? And I've got my car and my original house. Well, then the tiebreaker treaty will say residency is back in South Africa. Where's my habitual abode or nationality? So they go through different factors to resolve it. And if they can't resolve it, then it's by mutual agreement by the revenue authorities, which takes forever, which means you're subject to double taxation. So you never want it to be a competent authority on a tiebreaker clause. Then domestic law on tax residents, the resident companies. So again, when you look at companies, that's where the bigger issue is. You look at the place of incorporation or effective management as a general rule. You in Uganda, it's usually the place of incorporation, management, or control, or where you undertake the majority of your operations during the year. So what they don't want in Uganda is if you put your management, you put your directors abroad, but you are basically mainly operating with your daily activities in Uganda, they'll make a claim. So that one is a little different. We debated that one in South Africa. Where's the substance is what you're looking for there. We don't want you getting around the system. So again, the question is what happens with the treaty? Now, when there is a conflict with a corporate conflict, the newer rules go to competent authority. The old rules would go to a different space where you would say, where's effective management? And that always prevailed. And then there would be a way of going about it. The reason why they changed the rule of competent authority was there was a feeling that if you got yourself into a problem of dual resident for companies, you did it deliberately, because it's pretty easy to work it out so that your activities are where you belong. And so the newer system says, well, we're really going to both look at this very, very carefully if there's a conflict between the company, and we want to see that there's something genuine going on, and then we'll follow that. But we're not going to allow you to play artificial games with us. And so a lot of your treaties are older, so they don't necessarily reflect this rule, but I believe this is part of the MLI now. So you might be where you are. I think you've signed into the MLI now at this point. I'm not sure if it's yet effective, but the newer rule, you don't try to stay out of conflicts with company level conflicts. You're going to find there's increasing hostility there. Okay, but the bulk, okay, here's one. Let's see, add another one. Okay, here's a point on residency and source. By active income should be taxed primarily at source, while passive income should be taxed primarily on residency basis. I think there is some point to that. Let's see what he wrote there. He goes, active income should be taxed primarily at source, while passive income should be taxed primarily on a residency basis. I think what you're saying is an OECD view. The OECD view is if your active local activity should primarily be taxed locally. And the OECD is trying to say passive income, because it moves around so much, should primarily be taxed on a residency basis. But that word primarily operates differently in Africa. In Africa, that primarily is like more likely than not, or more than half. It's they're much more driven to source in Africa. But I think that's a nice summary. I like that. I think very good point. Okay. Now, just to go to the residency, my system sticks again. Okay, just to note, there are two kinds of investment offshore. There is foreign direct activities, where you've got the foreign home office and they have local activities, local branches, or you've got a foreign company that sets up a local subsidiary. Now, as a general matter, most serious investment happens through a local subsidiary, a local company. So if the South Africans are going to do something big in Uganda, they're going to set up a local subsidiary. So you'll see like South African banks have Ugandan subsidiaries, and typically the same for the UK and the others. So in the banking space, you'll see it. You'll see it also in the telecom space. So once the investment is serious, it's usually a local subsidiary. And if the local subsidiary, if the South African company has a Ugandan subsidiary, that Ugandan company is a full Ugandan company and does not receive any treaty relief on any of its income. So subsidiaries are fully taxed without regard to anything. The big one where you see the treaty popping up is if you've got a foreign company and it's got a branch. Now, you won't see a lot of branches in there, but you might see minor activity, which usually goes on through people. Like before they set up, they might have a few local salesmen or a few, local activities going on by some agents. And that's where they can accidentally pick up a trade or business in Uganda, and you find yourself in a dual taxation. But it's usually about people where the conflict comes, where they just haven't yet incorporated. And usually the thing is, companies don't want to be taxed by the local country unless they're doing something serious. So usually if I'm a South African company, I've sent a couple guys abroad, I really want to be just taxed in South Africa. I don't want to be taxed in Uganda because my activities aren't significant enough. And that's where a lot of the battle is. Are they significant enough? Are you playing games or not? And that's where there's got to be a lot of care. And a lot of times companies accidentally cross the line because people do things they don't necessarily want them to do. Then there's active and passive. That distinction is mentioned by Deus, that your active is taxed differently than your passive. If you're doing a lot of activities locally in Uganda, the treaty is going to say that Uganda prevails. You've got a permanent establishment with effectively connected income. And if that happens, done. And you'll see services and sale of goods is typically where that's going on. And if the Ugandans tax those activities, then all South Africa can do is tax the residual, which is any tax above. So right now, Uganda's got a 30% rate. South Africa's got a 28% rate. So South Africa won't claim anything. But, let's say you were a U.S. investor under old law, the U.S. used to have a 35% rate. So if they were doing service in Uganda and Uganda claimed it, they would claim the 30. And then because the U.S. had a 35% rate, they would claim the 5 differential. Now the rate in the U.S. is only 21, so they wouldn't have a differential anymore. So you've got the active side, which is primarily focusing on source, and then the passive, and that's where you see a mix of local and the residency based. And typically what is passive: dividends, capital gains, interest, royalties, other income, and immovable property. I'll go through that now. So we look at passive income, how it works. And I'm just got to keep an eye on my time because I'm going to jump through. But when you look at passive income, the typical case is you've got a South African who lives abroad and sets up a Ugandan subsidiary, or you've got a Ugandan parent company that sets up a Ugandan subsidiary. Well, what happens is the Ugandan corporate is taxed at its full 30% rate. But when it brings the money back to the South African back home, that's a Ugandan source dividend to be received by a South African. That's where the double tax is, and the treaty then goes to modify it. Now, without a modification, the way things would go for a dividend is that the dividends would be subject to a 15% rate in Uganda, and then the South African would be taxed on the differential. Now, it may depend. South Africa often has a participation exemption so that it would be exempt. Dividends coming abroad are not taxable because they want to encourage repatriation. but some countries will tax in full. But the way the treaty would go is, okay, the normal rate is 15% by Uganda, but the treaty is trying to reduce the friction of investing abroad, and it reduces the tax down to 10%. So there's a 5% savings with the treaty. I think Netherlands has the option of getting it down to a 5. I think that's one reason why that's a bit more contentious, the Netherlands treaty. But most of them are 10. Now, the point to note is that when you're reading a lot of the BEPS and the OECD stuff, the OECD treaty is likely to bring these kind of payments down to 5. So OECD style treaties tend to be much more residency country based. And so the Ugandan treaties, it's not bad. The typical line is the 10% with the UN, which is the African line. If you get treaty relief, it's more like 10. And if you look at Mauritius, it's 10, which most foreign countries don't love very much. I mean, the foreign investors don't love the 10. It's not the worst, but it's not the best for them. Let's put it that way. The other one is capital gains. So the typical OECD treaty would say that if you sell the shares in the Ugandan subsidiary, that there will be no tax in the local country. So if you had an OECD style treaty, which you might with Netherlands and UK, they could probably sell the shares without any Ugandan tax at the share level. I'll come back to that in a moment. So if they sell shares, typically you'll have a capital gain, and Uganda is very unique. So it's like, if you're looking at Europe, foreigners who sell local capital gains are exempt. That's it. So if an American sells French shares, the French won't tax it. If French people go into America and buy American shares and sell American shares, the American won't tax it. So that's the OECD rule. But Uganda says if a foreigner sells Ugandan shares, there's generally going to be a 30% charge. Okay. Now, I think it's reduced down to 10 in some cases, but the older ones would reduce it to 0. So Uganda has this view that we want capital gains at source by foreigners because it's their property. A lot of people have a lot of trouble with that because it does discourage foreign investment. That is the Indian position as well. And India will tax the locals. And a lot of times you'll see multinationals trying to get around that through Mauritius, but the Mauritian treaty has been changed, so that no longer works. So there is usually treaty relief on that one, around 10%, if you can get it, but a lot of times there is no treaty relief. But more significantly, what happened was Uganda put in another rule and said, if there's a more than 50% change of ownership at the shareholder level, we are going to deem the underlying Ugandan subsidiary as if it sold all of its assets. And the reason why they did that was they wanted to make sure that the treaty wouldn't ever apply. So when you have a shareholder change, the underlying corporate tax is triggered, which has no treaty relief. And they got this one from Tanzania. And that is can be very harsh because a lot of times the change of ownership is not, it's just a restructuring. So if you have a multinational group, say a big oil company, they might be changing ownership with the direct owners, but the ultimate parent has the exact same interest. And so that's where a lot of the battles are going on there. And then there's also the issue for sale. And I think Tullow Oil is your famous one there. But the key is that more than 50% change. Then to note some of the other expenses, because my time is moving against me here. Dividends are one, and there's a lot of rules around dividends, but dividends aren't a big threat to the tax base. What is a big threat to the tax base is interest, rents, and royalties. Because interest, rents, and royalties are going out of the country in corporate. And let me just take the chat here for a moment. Okay, that's fine. Edward said you can kindly post any questions you may have as we move here, because we're now getting to the Q&A, but I'm still talking. So I'm happy to take questions if you want as we go. When the corporate subsidiary pays a interest, let's say, to a South African, well, what happens is two things. Is that one, the South African will receive interest income. So the question is, well, that's taxable. But the problem is interest, rents, and royals generate a deduction. And the deduction reduces the underlying 30% Ugandan corporate tax. And that's where the treaty doesn't really do anything there. And that's where a lot of the concerns have been. That what will happen is money is going out the door, you're not taxing the interest. And what's happening is the interest is offsetting operational income from the Ugandan subsidiary. And that's where this base erosion is, that there are deductible payments that are going out of the country. Sorry, we're gonna go back. So what Ugandan generally does is they have a 15% rate on the interest, which is reduced to 10. But now I've got 505, ignore that, should be say deductions to 50% parent companies. The concern though is, even though you're collecting a withholding tax, the interest deduction is eliminating the 30% corporate income tax on the Ugandan rate. So if deductions are paid to a 50% parent company outside the country, you have a thin cap rule that reduces the debt to equity ratio down to 2-to-1. What you also have is transfer pricing that will limit that interest deduction as well, depending on what it is. And so you'll see that dual level going on. And that's what base erosion is all about, that the elimination of the tax is going on at the underlying level, and the treaty is reducing it at the top level. Now, in South Africa, it's not a big deal at the top level, because in South Africa, even though the Ugandan income disappears, you'll find that South Africa is going to tax it in full. So the company is not doing anything evil, because they're just paying interest, and South Africa is taxing the full amount instead of Uganda. The problem is that the fight now is Uganda's losing out to South Africa. Whereas if you have to worry about Mauritius, that's where these battles began. The money would not be taxable in Uganda. And then what would happen is the treaty would limit the withholding tax, and Mauritius would not have a tax at all. So that's where the global avoidance would be. And let me just jump to that, because our time is getting up as we go. So I've got a lot of things here. When you're looking at treaties, the biggest worry now is about treaty shopping. That's where the avoidance element is. But there are two battles going on. One is avoidance, where you're finding yourself, by playing a few clever games, a multinational can reduce its tax to zero, like Starbucks and Amazon and all of those. And then there's simply, each country wanting their share. So a South African company that invests into Uganda, the battle is, does South Africa take the tax, or does Uganda take the tax? And that's the one that worries companies, because they're both fighting for a tax base and they both want it. And then you find it becomes prohibitive to invest abroad because you have double taxation. All right, let me get rid of this. So the point is, playing music. I don't know why that went off, but okay, here's a chat. Oh, you recently replaced the 2-to-1 rule. Okay, sorry about that. Yeah, I was looking at the old law. I dug up something on the old law that showed me a 2-to-1. But yes, you have a 30% tax EBITDA rule now. A number of countries have done that. So the old thin cap was 2-to-1 ratio. The ratio now is 30% of earnings before interest and tax and depreciation. And that rule of the 30% EBITDA on the interest deduction is the new rule. It started in Europe, I think with Germany and Denmark and Italy. We picked it up in South Africa. We have something called a 23M that has a 30% EBITDA rule. And the reason why we have that rule is that banks usually won't make loans beyond that. Now, that rule can be a bit restrictive, because in the case of real estate, they will go to 40. Where you see a capital intensive project, they'll go higher. And so the 30% may be overly restrictive in some cases. It's non-economic. And it really should be adjusted where a capital intensive project is this, it should really be allowed to about 40%. But people are doing across the board rules. I think they've done it here. And I know there are a few other African countries have done that as well besides South Africa. So thanks for that point. And I stand clarification. Okay, on the treaty itself, treaty shopping is this. What you've got is you've got 3 countries involved and you want to invest in A. And country, what will happen is, let me know withholding rates. You've got 3 ways to go. Let's just do it this way almost to make it easier. You've got a South African parent, you've got a UK subsidiary, a Ugandan subsidiary. Uganda's got a 28% rate. South Africa's got a 28% rate. Uganda's got a 30% rate. If South African parent directly invests in that Ugandan subsidiary, well, the treaty will mitigate it. So you'll either be 30 or 28. So that's not a big deal. The concern is if you put a holding company in between, and the typical holding company was Dubai, Mauritius, Netherlands. And there they have a special rule that says holding companies will effectively be taxed at 0. And what would happen is the Ugandan subsidiary would pay interest to Mauritius. They would pay deductible interest, so that would reduce Ugandan tax. They would have a small withholding, and then Mauritius wouldn't tax at all. And so you'd find the rate would go from 30 down to 10 or less. And then the money would sit there in Mauritius and never go back to the South African parent. And so the way the South African parent would try to solve it is with CFC legislation, which didn't always work. And then the other country would try to get it withholding or anti-avoidance and transfer pricing. So what you've seen is a tax on, well, is the Mauritian company really a beneficial holder? So one of the issues is you were trying to change the rules around beneficial ownership. But beneficial ownership is a treaty concept. And typically, if you've got a couple people there and management there, you'll have the ownership. But you have changed your beneficial ownership rules. You're trying to make it a little bit stronger. But again, there's the treaty. The way around it is increasingly the MLI has done is they've said, if you're in Mauritius and the only reason why you're there, and one of is for tax avoidance, we're going to go after you. So I'm about to close. And they have a new rule in the MLI, which the Ugandans signed, that says if one of the principal purposes of being in Mauritius is for tax avoidance, we're going to shut you down. So that rule is yet to be played, and you also have a more than 50% rule. So if your Mauritian parent company is more than 50% owned by foreigners outside of Mauritius, then the Ugandan law will say the treaty does not apply. Let me just answer this question and then we'll go there. Okay, we need a copy of your presentation. The end, yes, you can have a copy of the presentation. I think I've sent that through. And I think that's the note to shut it down from my narrator. Is that correct? So I will close at this point. Here's another one I'm just seeing.
Prof, you can do an additional 10 minutes.
Oh, I have an additional few minutes? Okay, let me see here.
Sure.
Well, first, let me answer the question. Okay, let's see. 30% is drafted in a way that limits deduction. Okay, the 30% limitation you've got is drafted in a way that limits deduction of interest by any company that is a member of group, even if the company in Uganda has borrowed from a third party who is not a member. Now, this is a bit of a problem. The way these work, these 30% limitations and these thin cap rules work. They're really designed, and the avoidance is when you have connected parties. So there are a number of, Uganda has a number of anti-avoidance rules, so does South Africa and others, where the anti-avoidance is between parent and sub. And the reason why the avoidance is there is because what happens is that you've got one economic group. So if you've got a parent and sub relationship, you're one economic group, they don't care who makes the money. because either way they win. They own both sides to the transaction. So the anti-avoidance rules should really be limited to group taxation. But what's happened is people say there's certain schemes that get around it. And so they just apply a 30% rule across the board for anti-avoidance sake. And that's really wrong, because a lot of times, if you have an independent bank giving you a loan, that bank is real. And then that 30% cap shouldn't apply. And unfortunately, too many countries are now thinking so much in anti-avoidance, they're really becoming anti-taxpayer. And that's making things very problematic. So I agree with you that they should limit it. But unfortunately, countries and along with academics are really not thinking business anymore. And I think over time, it's going to begin to tell where you're going to see the tax systems impeding investment. And people are going to wake up to that. And hopefully they're going to solve it in a moderate way and not go to extremes. So that's just where we are on that. Okay, I've got a few minutes. I can carry on. So one of the, as I said, the MLI will say a principal purpose test. That has not been tested yet because it says one of the principal purposes. Now, the way the MLI works is even if you have an old treaty, if you sign on to this thing and the other parties sign on, you can quickly override the old treaty. So you always need to look at the old treaty and the MLI to see if the MLI overrides. And that a lot of them haven't fully signed yet, so you won't see it in full, but you will begin to see this more and more. Now, what's one of the principal purposes? I think it's going to be a real problem, because if you're going to go to Mauritius, how are you going to argue that one of the principal purposes is not tax avoidance? I think it's going to be very, very difficult for you because tax is an element there. If you're going to another country that's got, the only way you can do it is if you have a lot of substance. But then the question is the substance good enough? Even if you've got real substance against the one up. So that's going to be tested. I would take a look at tax treaty law. Now, when you look at tax treaty law, that you can't just look to South African law. You've got to look at how other countries are doing it around the world. And you'll see more and more in that as we go. There is another test, as I said here. There's also called a limitation on benefits clause, which I alluded to. The US does this. They just say, look, we don't care about your purposes. If you're claiming to be a treaty resident of that country and that company is more than 50% owned by people outside the country, you lose. And that's what Uganda's done. They put that into their domestic law, and this is 88.5. So if you've got a foreign parent where 50% or more of the shareholders are from a different country, we don't really care about the treaty. And 88.5 will just disallow that treaty benefit. And there was a case called White Sapphire that basically said it's not in violation of the treaty. If there is a treaty issue, go to competent authority. And so White Sapphire is basically saying that treaty doesn't work. And I think you're going to find that that kind of game isn't going to play. So if a South African is going to come to Uganda, it's better to go direct. I think, White Sapphire is not being pursued, and that's legitimate law. And 88.5 stands as is at this point. That's where we are on that one. And then let's see here. I think, did you want me to continue? I'm not sure how much time I have left. Just to say about MLIs in closing then. The big thing that you've got to keep in mind in these treaties is treaties are designed to avoid double taxation. But what you are seeing across the world is the worry about avoidance and what's mine is mine, and you shouldn't get too much. And what you're seeing in Uganda, as in elsewhere, is this claim for jurisdiction. And you can even see with the EAC agreement that Tanzania still hasn't signed. So what you're finding is revenue authorities are trying to claim as much tax from foreign investment as they can. And areas where it's coming up, it's a lot of dispute. So revenue authorities are auditing foreign investors a lot. And when the other areas that the battle goes on is transfer pricing. And, is it my activity? What did you do in the local country? And countries are trying to claim more and more with transfer pricing. And this is where a lot of the disputes are going on. And you'll see that you really got to do a transfer pricing analysis to make sure that where is the activity. This is very fact-based. And I know that you're going to be discussing this later. We've got a few people coming in, and I will close to let people know that we are having a transfer pricing conference at the South African Institute on Friday, where we've got an army of experts on that. So I'll give you a plug. You can take a look. Transfer Pricing Summit. It's very African-based, but really you need a set of experts. So when you're doing international tax, it's not enough to just know law. You've got to know the factual transfer pricing as well. Let me take these two chats and close. Let's see here. Oh, I see there's another case. Burlington Loan Management is saying that you don't have to be related. Okay, this is here, this is what you're saying. Burlington Loan, this is a recent case on principal purpose test from the UK. Okay, interesting. I'm not aware of that case. I will take a look it up if you want to make a note there. I'm curious to see what that was, if it's the one of the principal purposes or the principal purpose. Big difference. So, but maybe you know that it's the newer one. Okay. Thank you so much.
Thank you so much, Prof, for the presentation and doing justice to this. We are grateful and thank you for your time. I think you've answered all the questions, including the future of DTS, given developments like the MLI. So thank you so much, Prof. Back to you for the next presentation.
Thanks so much, Professor Keith Engels, together with Edward Balava. That was a wonderful presentation. If we had more time, we would have loved to listen. There was a request that you will share the presentation, the slides, and I think that will be honored. Well, we are on track. The next presentation is going to be made by Mr. Augustine Chigundu. Augustine Chigundu is currently a partner at the Mighty Otis Advocates. And before that, he had extensive practice with Ernst & Young. So he's really the best person for this topic. He's going to be taking us through disputed transfer pricing. Augustine, are you there? Yeah. Over to you, Augustine.
Yes. Thank you very much, Tony. Just confirm that you can hear me loud and clear. You
are very clear.
Okay. Thank you very much. Hello, members. As introduced, I'm Augustine Chigundu. I'm a tax consultant and a partner with Otis Advocates. I have a pleasure to share insights on the little I know about this subject of transfer pricing. Many people perceive this topic to be a very complex topic, but as you later see from my presentation, this is really about comparative analysis. It's not as complex as most people presume it to be. Now, I have 45 minutes to share my insights. If you would just allow me to share my screen. Okay. Okay, so in the 45 minutes, I will talk about, first of all, I'll give a brief introduction about this subject of transfer pricing and the rationale for transfer pricing. I will also talk about what is referred to as the arm's length principle. You can't talk about transfer pricing and not talk about something known as the arm's length principle. I will also talk about what we call the OECD guidelines. And we'll later see that some of these guidelines provide for some of the dispute resolution mechanisms that we see mirror in our domestic tax rules, and specifically the subject of transfer pricing. I will also share my thoughts on what it means what we mean by transfer pricing compliance and risk management. It's important because when you talk about disputes in transfer pricing, disputes arise from failure to comply, failure to manage risks. So my presentation will talk about how do we manage some of those compliance issues, and then the risk management as well. I will also share insights on the TP dispute resolution mechanisms, those provided for under the OECD guidelines versus those that are rooted in our domestic laws, tax laws. And if time allows, I'll share a brief on one or two cases on TP cases, and let's see how the discussion will go on.
Augustine, there is a challenge with, I think you have a network surge. I don't know whether you can shift a location or try to solve that. Okay, colleagues, let's try to wait for Augustine. He has been taking us through his introduction to the dispute resolutions under transfer pricing. Yeah. Let's give him some time. Augustine, your own, kindly share the screen again. Yeah.
Sorry about that. Sorry about. At least 2/3 of all cross. So, can you hear me now?
We can hear you now.
Okay. Sorry. I think I see a signal of unstable network. So just let me know once I drop off. Yeah.
Okay.
Okay. So I was saying, whereas this cross-border trade and investment is vital to economic development, it's essential that developing countries are able to collect taxes on the profits that these multinationals earn or generate from the countries in which they operate. And you have to do so in such a way that you do not distort the international trade practices. Now, multinationals are notorious for engaging in tax planning strategies that exploit gaps in tax rules. It's an unfortunate instance, but they're very notorious for that. In a scheme known as the professor alluded to, what we call the base erosion and profit shifting, BEPS. So what BEPS ideally means, you're eroding that national tax base. So under this scheme, you're able to shift your taxable profits from a jurisdiction that probably charges a higher tax rate to those jurisdictions that do not charge or charge very little taxes at that. Now, I'll give an example. We'll consider, for example, a company A domiciled in Uganda with a taxable profit of 1 million. So currently, that company would be required to pay a corporation tax of 30%, which translates to about 300,000. Now, suppose, now we're just switching up this, trying to spice up the dynamics here. Supposing this particular company was owned by an entity domiciled, say, we've been talking about Mauritius. Mauritius has the tax rate, effective tax rate of about, I think, 15%. So it would make more commercial sense for this group of companies to try and push these taxable profits from a country like Uganda that has a high corporation tax rate to a jurisdiction like Mauritius that has a lower tax rate. If you're using the example of a tax rate of 5%, if you find a way of moving the 1 million taxable profit from Uganda to a jurisdiction, say in Mauritius, you realize that the group, instead of paying the 300,000, which would have been taxed on the subsidiary in Uganda, would only be paying 50,000, which is tax paid in Mauritius. Now, there are very many ways of doing this. For example, the Mauritian entity can just charge the Ugandan entity a management fee of 1 million. By just that charge alone, you've shifted the taxable profit that the Ugandan entity would report in Uganda to Mauritius, where they're going to report it, yes, and then be taxed at a very lower rate. Now, of great importance, of course, is this tool of transfer pricing. So transfer pricing comes in as a tool to regulate or battle this, what we call the BEPS, the base erosion and profit shifting. So what is this transfer pricing anyway? Transfer pricing basically refers to the price at which goods or services or intellectual property or whichever that is transferred between related entities. A related party in this particular case will refer to that member that is commonly controlled by a group of entities. Now, transfer pricing is important, most especially for a group of companies, because one, it directly affects profitability of the entities under the controlled group. And here we look at, when we look at issues of consolidation, then that tool becomes very, very important. It also defines the values of goods and services transferred between associated entities. And this plays a key role in the measurement of performance and other value drivers. Now, transfer pricing, I just picked up a note there. It's a topic that is of great significance to multinationals. In fact, any conversation you have as a tax practitioner, as a consultant with a multinational entity, the issues of transfer pricing will always be brought up. And this is the reason, because whereas these companies are trying to craft their transactions in such a way that they pay little taxes, we also have this set of rules that is actually available to try and cap this. Now, moving on to the issue of the arm's length price. Now, the arm's length price or arm's length principle is the bedrock of any transfer pricing. And locally, it's rooted in our Section 90, subsection 1 of the Income Tax Act, which generally provides that transactions between associates, the commissioner may attribute, distribute, or portion, allocate income as may be necessary to reflect those transactions as would be consistent with the arm's length principle. Now, we have a whole section in the Income Tax Act on who an associate is, and that is Section 3. And that varies from a relative in terms of a natural person to control test for the artificial persons. Now, the transfer pricing regulations also now require that transactions between associates are consistent with the arm's length principle. So what then is the arm's length principle? So that principle is defined in the regulations precisely to mean, so in relation to a controlled transaction, to mean results that are consistent with the results that would have been realized in a transaction between independent persons dealing under the same conditions. This definition is consistent with the definition under Article 9 of the OECD Model Tax Convention on Income and Capital. Then also, we have a whole chapter on the OECD transfer pricing guidelines on the arm's length principle. So currently, the standard is where we have transactions between related entities, those transactions should be at arm's length. I'm just trying to put it in simple terms, that if a stranger just sauntered into your chambers and asked you to prepare for them a power of attorney, and you charge them 100,000 you're just using an example. What the arm's length principle is saying that if, for example, your uncle also stepped into your chambers and asked you to prepare a similar power of attorney, then why are you charging the stranger 100,000 and charging your uncle, say 50,000 or even 200,000? So the whole dynamic around transfer pricing is just that comparative analysis between the prices that you charge to independent entities versus the prices that you charge to those related entities. So therefore, the gist of transfer pricing is that it's a comparison. It's a mere empirical comparison between those transactions. The transactions happening in a controlled environment versus the transactions that are happening in an uncontrolled environment. This is based on an assumption, of course, and someone may ask, why do we compare the two? So there is an underlying assumption to this. And the assumption is that when independent entities transact, the conditions of commercial and financial relations are ordinarily characterized by or driven by the market forces. Whereas where related entities are transacting, those conditions may not be necessarily driven by the market forces. So that's why when we are running a comparative analysis for related party transactions, there are certain factors that we look out for. Under the guidelines, there are those that I've listed on the screen. You'll see we look out for the characteristics of properties or services transferred between the parties. We look at the functions performed by the parties. We look at the contractual terms. We look at the economic circumstances of the party, the business strategies pursued by the various parties. So if you're to move on and look at this thing, what is it that we mean by OECD guidelines and the transfer pricing methods? How do we then determine the transfer price? Now, the OECD, in full, it's the Organization of Economic Cooperation and Development, is an economic organization of member states founded to promote good economic practices. Currently, the membership is just 38 countries, but based on the rules, the treaties, they have entered into various treaties with various countries, but their membership is a bit tight to just those countries that have expressed a willingness to practice and promote those good economic practices. So they grapple with so many things. Currently, they've just released guidance on how to tax the digital economy. Very many of us, of course, in various forums, we've complained, how do we get to tax this? You've seen the URA trying to impose that VAT on electronic service providers. So even this organization sits to try and come up with best practices around some of these economic challenges. So they have developed rules that seek to reduce or eliminate this aspect of base erosion and profit shifting among multinationals. And from a transfer pricing side, they have the first set of guidelines were released in 1979. They were updated subsequently, and I think currently the latest that apply are the OECD transfer pricing guidelines of 2022. So over time, they keep meeting. They have, I think, the best. I think Professor should be one of the members on the panel of consultants for the OECD Council. They come up with ways in which they try to address the taxation challenges governing their members. Now, the OECD guidelines that we're talking about, the OECD Model Convention on income and taxation of income and capital. Then we also have the OECD guidelines on the transfer pricing guidelines. All these are applicable in Uganda. This is by virtue of, I think, Regulation 6 of the transfer pricing regulations, which provide that the application of those regulations should be consistent with the principles stated in those particular guidelines. So that creates the window for the application of these OECD guidelines. Like I've indicated, these guidelines are based on what we call the best practices, international practices. And our application to them in our Ugandan transfer pricing situation is by virtue of that regulation that says in applying these regulations, they should be consistent with the transfer with these particular guidelines issued by the OECD. And regulations are emphatic that in cases where there are any inconsistencies between the actual regulations with those OECD guidelines, then the act prevails. So I will now turn to, yes, now we found out that if we are transacting with the related party, we need to ensure that that transaction is at arm's length. But then how do we determine that arm's length? Now, the methods that are provided for in the guidelines, together with the regulations, they're more technical. They're more technical in nature. In fact, these are normally for people that what we call the transfer pricing practitioners, and I think this is where most people think this subject is a little complicated or complex. So I will not dwell so much on those transfer pricing methods. I'll talk through them, but I'll not dwell so much. However, as I indicate, in absence of market prices, standardized methods to help determine the arm's length price have already been set. The selection of the transfer pricing method should provide for the most reliable measure of an arm's length result, resulting from a controlled transaction. And you have to look at the given circumstances and facts of particular nature. So primarily, we have three factors we consider when selecting the most appropriate transfer pricing method. One, we look at the nature and complexity of the transaction. We look at the degree of comparability between the taxpayer and the comparables. So there should be some level of comparability between those two. Then, of course, the other aspect is the completeness and accuracy of the data that you rely on. You will not just pick data from unverified or unverified sources on the internet and seek to use them in determining your arm's length price. Now, there are certain instances where two methods have been used to determine the arm's length. What technically we call the corroborative method. So you have the primary or principal method, but then that is corroborated by a second method. Now, in terms of the methods, we have basically three broad categories of transfer pricing methods. So we have the traditional transactional methods, we have the transactional profit methods. Those mainly concern themselves with profit. And then the guidelines also provide for any other method, which, and here we need to be very careful. They provide for any other method, but you have to justify that the above methods do not or could not be used sufficiently to determine the arm's length. So very quickly, through the traditional transactional methods. So in theory, the comparable uncontrolled price method is regarded as the best method. And here what we are looking at is you are in a trade or you're trading with independent parties and at the same time trading with the related entity for the same products in the same market space. So that method, once we have that sort of circumstance within our circumstances, then it's the guidelines say the best method you would use would be that comparable uncontrolled price method. So you're just comparing the price that you would charge an independent entity versus the price that you're charging the related entity for the same product in the same market. The other method is the resale price method. As the name suggests, it's based on a comparison of a resale margin in a controlled environment. It's normally applicable to distributorships and where there is no significant or substantial value addition to the products that you're dealing in. So here we're just looking at, yes, we have a related entity that is doing the distributorship. We do the manufacturing, but then we have an entity that does the distributorship. No value addition whatsoever. It's just for purposes of distribution. So we are saying in those circumstances, when you're determining the price, then this method would be a very nice fallback method. The other traditional method is a cost plus. Now, this one starts with the supplier cost. So we're looking at, say, for example, a manufacturer. What cost have you incurred in building up this product? Then, after building up this product, what profit do you want to achieve? So the challenge there with this method would be that it presumes that you need making perpetual profit on that product. So that's one of the criticisms for this particular method, and it's normally used for instances where there is some substantial value addition to the product by that related entity. So whereas the resale price method is just purely for very low value addition, this one then would be applicable for instances where there is some substantial value addition to that to the production process. Now, when you cross over to the transactional profit methods, now those are mainly interested or interest themselves in the profit that you're making. So under the profit split method, so ideally here you compare the division of profits or losses that a person achieves in a controlled transaction with the division of profits or losses that would be applicable in an uncontrolled transaction. So here, it's normally used when parties or the activities are so intertwined and it's difficult to determine each party's risks involved. So here now you're looking at how so here we're looking at Tony, am I on?
Kindly repeat that point. You were on, but repeat that.
Yes. I was saying the profit split method is normally used where the activities involved are so intertwined that it's difficult to determine where each party's risks belong. So if you have an independent comparable where this profit split was used and applied, then you can apply the same to the circumstances of your related party transaction. Now, this is different from the transactional net margin method, what we call the TNMM. Now, this applies when you're comparing the net profit margin relative to an appropriate base. So here we're using profit level indicators mainly. So, for example, we're looking at margins compared to bases. We're just giving an example of, say, profit to sales ratio. So this method works a lot with those ratios. You're looking at profit to costs. You're looking at profit to assets. So when you're looking at that, that's when you deploy this transactional profit method, what we call the TNMM. Like I said, these are more technical aspects of the subject. It's mainly that the transfer pricing practitioners that will find them of greater interest. But I felt it's important for us at least to have an overview of the methods that we deploy when we're determining the transfer prices for related party transactions. So quickly, then I'll focus more on the compliance aspects. Now, compliance in the context of transfer pricing is predominantly achieved by that demonstration of the arm's length principle. And that is where the predominance is. However, when you read through the documents, when you read through the guidelines, you see that it's not sufficient for you to transact on an arm's length basis. There is a necessity for you to demonstrate that you're transacting at an arm's length. So it's a dual obligation with penalties on both sides. I think if you do not have transfer pricing information, it could be guided. I think the penalty is now 50 million. So we see that whereas you may have transacted at arm's length, the regulations are saying that you need to have sufficient documentation to support that insistence on the fact that you transacted at arm's length. And that insistence is by having that documentation. So when you look at Regulation 8 of transfer pricing regulations, a taxpayer is required to record in writing, yeah, sufficient information. So there is that emphasis on sufficient information and analysis to verify that these control transactions are at arm's length. And actually, the regulations further provide that this documentation needs to be in place prior to the timelines of filing of your income tax returns. So preparation of transfer pricing documentation, therefore, should be more than just that simplistic compiling of documents to try and justify your arm's length principle. So the preparation of the documentation itself, should involve an assessment. There should be some sort of analysis. Say that, yes, this is the price that we're charging the related entities, but it's at arm's length because we undertook a certain study, and this study is backed up by the following documents. So therefore, in undertaking a transfer pricing analysis, we do include things like an industry analysis. I'll discuss that later. Company analysis. We look at the functional analysis, and then the economic analysis, which supports what we call the conclusion to support the arm's length price that you're charging your related entity. So it's important to understand your business, therefore, and ensure that you can support those very transactions. It's important for our clients or even the taxpayers on board that you need to understand all those intra-group transactions. You need not to leave them to the head office. We've seen instances in practice where, for example, a local accountant here in Uganda receives an invoice for a management fee. They don't question it. It has come from the group. We just have to book it and make sure we pay it. We don't ask. Now, this creates issues around transfer pricing. So there's need to understand, first of all, what qualifies as an intercompany transaction. Then there is also need to understand the documentary requirements that you need to put in place to show that these transactions are at arm's length. So when you're preparing a transfer pricing document, the following should be at the back of your mind. So when you're undertaking an industry analysis, so here we're looking at the value drivers in the industry. What does the industry look like? Where is the industry headed? So before you jump onto the particular transaction, it's important to have an industry-wide perspective. When you're doing a company analysis, you look at what accounts for that particular company. Now we are zeroing it away from the industry. Now we're going into the company. What are those factors that drive the company's performance within that industry? We normally do what we call a SWOT analysis to try and see what good things are those that the company is doing. So the other aspect is when you're doing the financial functional analysis, rather. So you're looking at the roles played by each of these parties in the transaction. What risks are we looking at? When you're looking at the entity characterization, what are the key contributors of the parties to this particular transaction? When you're doing an economic analysis, and this is very important because this is where now you have to justify the transfer pricing method that you've used, together with that conclusion that my prices are within the acceptable arm's length range. Now, because of what is perceived as the complex nature of this subject, the URA issued a practice note still to guide taxpayers on the documents that are required. And this practice note, well, it said the transfer pricing regime applies to all multinational entity transactions. And also now here we're looking at the control transactions, the local transactions. So we have groups that are locally domiciled. So if those groups have transactions within related entities, then the control transaction should be an aggregate of at least 500 million. Now the documents there, as you can see, it's a bit of a detail. I just picked out a few that I felt was necessary for us to pay close attention to. So you're looking at the company details. So they want to look at the ownership and organization structure, operational aspects. When you look at the transaction details, you want you to describe that transaction. What is the scope, timing, the value? All these things need to be in place. They want to look at the agreements, the comparables that you want to base on to say that yes, my transfer price is at arm's length. They want to see all that. That should be backed by documentation, and then your economic analysis. So you have to give your analysis of yes, you've looked at the comparables, you've looked at the risks involved, the function, the assets deployed by the entities. They want to see that analysis of how you come to the arm's length price. Then they also want to see in the determination of your arm's length price, the statement on the transfer pricing method used and the reason why you used that method. Then they also want to look at those other functional analysis risks. Is it a credit risk? Is it a market risk? All those should be part of the documentation. And then finally, you need to have a statement on whether, after analyzing this transaction, it falls within the arm's length range. Short of that, then you'll have issues with the taxman. And that brings me now to the section of my presentation on TP disputes. And here we're looking at what the OECD guidelines say versus what our rules in the domestic tax laws provide for. So now under the OECD guidelines, they hint on those dispute resolution mechanisms. They look at the audits. They also look at the mutual agreement procedure. They look at advanced pricing arrangements, and then appeals and litigation. Now, for the tax audits, well, this can be a very resourceful tool in raising revenue. But of great importance is the need to know that transfer pricing audits are very fact-intensive and may include difficult assessment of comparability or judgment of the industry or market and financial information. So it's important that when you're looking at that dispute resolution mechanism, it's important for you to understand that where we're coming from, transfer pricing by its own nature is very fact intensive. So as a consequence, it's important for the taxpayer, on this particular aspect, the related party that is under audit, first of all, to maintain a critical understanding of the underlying transaction. Okay, so it's necessary for you to have that knowledge of that transaction. In fact, the guidelines recommend that this entity should at least devote, say, maybe one or more persons specifically for purposes of responding to these tax audits. Otherwise, you'll have so many people giving information to the tax auditor, which may then lead to inconsistencies and improper judgment. So it's also important to note that whereas the OECD guidelines recognize this as one of the dispute resolution mechanisms, they also are cognizant of the fact that audits are governed by the domestic and the domestic legislative procedures that are in place by the various tax authorities. The other is what we call the mutual agreement procedure. This is, you'll find this under Article 2025 of the OECD Model Convention on Taxation of Income and Capital. This particular procedure is outside the domestic law. But yes, whereas it's outside the domestic law ring, why are they proposing it? So they're saying that this procedure enables this particular taxpayer to reach out. So you initiate that conversation with the tax authority. Sort of agree on a procedure to adopt when determining this tax price, transfer prices. Now, this procedure is mainly used for the, for lack of a better word, not very technical aspects. For example, you have TP issues around withholding tax, attribution of profits to a permanent establishment, or even in aspects of determination of residency. So here, we're looking at something that has already happened, and now you're reaching out to the tax authority, and you're giving them this set of relevant information, saying, yes, this is the sort of transaction that I entered into. We have this treaty provision in issue. This is the relationship I have with this entity. This is the summary of my facts. This is what happened here and there. Please, let us agree that for purposes of the determination of my transfer price, this and this should be the criteria set. The other is the advanced pricing arrangement. As the name suggests, these seek to determine a set of pricing criteria for a controlled transaction in advance. So here you anticipate that you're going to enter into a transaction, and look at the transfer pricing methods. You realize that there may be issues around the determination of the transfer price. So under this mechanism, the taxpayer initiates that conversation. And this can take on various forms. For example, you may have the unilateral advanced pricing arrangements between the taxpayer and the tax authority. You could have the bilateral advanced pricing arrangements between the taxpayer, the tax authority, and a foreign tax authority. Then we also have provision for the multinational advanced pricing arrangements. These could be between one taxpayer, the tax authority in which they're domiciled, and then two or more foreign tax authorities. Now, those are basically the transfer pricing dispute mechanism listed under the OECD guidelines. The OECD guidelines also hint on the appeals and litigation mechanism, but that's, of course, they acknowledge that it should be driven by the domestic laws. Now, when you cross over to our side, the local side, I've listed for you some of the dispute resolution mechanisms, specifically for the transfer pricing. The first one, like I've already discussed, on the advanced pricing arrangements, the agreements provide, the regulations rather provide for this form, where before you get into a transaction, you're not very certain about how you determine or how you're going to determine the transfer price. Then you can initiate that conversation with the tax authority, or the tax authority with another tax authority, to try and see that you have some sort of mutual understanding. The audits, like I've already indicated, these transfer pricing audits specifically can be very, very, very intense in terms of collection of facts and figures. So it's important that you have someone that understands or has a depth of an understanding of these controlled transactions. The others, of course, the assessments, those work hand in hand with the audits. So most especially after an audit, you expect to see some sort of assessment. Then the objections procedure, the appeals, or the alternative. These, I guess, the other presenters will talk more or speak to them more in greater detail. Tony, I don't know if I have a few more minutes for me to go into just one or two cases.
No, it's fine. You can use an extra 10 minutes.
Okay. Thank you. So the one case I would just want to point out to the members, it's an Indian case. This is Cushman and Wakefield decision. Here, the taxpayer had received certain services from its associated entity. And then the issue here was that entity had been charged actual costs. So there was that allocation of actual costs. So this taxpayer felt it wasn't necessary for them to run some sort of benchmarking study. They felt these are actual costs. There's no need for benchmarking for purposes of determining the arm's length. And the issue here was whether that the costs charged or recharged, those recharges at cost, whether there was need for that benchmarking analysis for purposes of determining the arm's length. And the court in this particular case ruled that although the transaction involved recovery of costs, the transaction was between two related entities, and as such, there was need to test that particular transaction in an uncontrolled environment. So the lesson we pick from that is all related party transactions need to be benchmarked to determine that the transaction is at arm's length. There's that practice normally that, and I see it in some of the policies that I read. This was recharged at cost as such. There's no need to run. There's that risk that should there be an audit and you ask to justify this, then that decision is saying that for as long as there's a related party transaction, then there may be need for that benchmarking exercise. The other is a Canadian case from the Supreme Court of Canada, GSK. And this also involved that particular Canadian entity importing goods from an affiliated company. So the tax authority there attempted to revisit the values that were declared for customs purposes. So the issue there was whether that price that was charged by the affiliate was reasonable in the circumstances. And yes, the Supreme Court takes note of the existence of the transfer pricing regime, but then goes ahead to note that this regime does not exist in a vacuum. So it doesn't operate outside the rims of the ordinary business environment. So there was need for whoever was trying to challenge this transaction to understand that transfer pricing, it being a science, is also alive to the general business realities that would face any other business. From a Ugandan side, I'll ask members interested in the MTN versus URA case, where I think there was a management fee of about 3% of the annual revenues of MTN Uganda being paid to MTN Mauritius. And the issue here was whether that was justifiable. Interest yourselves in the Salini versus URA case. This was there was an interesting issue on whether the TP regulations, which came into effect in 2022, applied 2011, applied to transactions prior to that. There was also another interesting one from Kenya, I think the Unilever case. Yes, there was some partial settlement on that matter, on some aspects that we felt court should have pronounced itself on. But precisely, just for the members interest themselves in those disputes. I save a few minutes here. Unless there are any questions, I beg to stop here for now.
Thank you so much, Augustine, for the presentation. You've taken the members through transfer pricing disputes. Members, then, if you have questions that you have not asked now, you can post them in the chat, and then later on they will be answered. But it was wonderful And in Uganda, I think our TP is still developing because the aspects you talked about and those that are provided for in the TP guidelines and the OECD now 2022 are yet to be actualized. When you talk about advanced pricing agreements or APAs, we are yet to see a taxpayer willing to go through the process of an APA. But still, we look forward to that. Then for disputes, we are yet to really see a pure TP disputes on method, like you look at the Unilever one of Kenya, but still we are forward to that. Now, Augustine, before you leave, there's something I would request you to comment on. It has been posted in the chats from Matthias. Thanks, Augustine, for a great treatment of a complex subject. Foreign-owned subsidiaries in Uganda regularly pay for services and IT resources from other group entities. The Ugandan subsidiary would normally just receive an invoice for the services at the end of the year. At what point should the Ugandan entity engage URA? Augustine, there's a question in the chat. Mawea, we handled one case where that might come out, but kindly quench Matthias' issues.
Okay, thank you. Matthias is my OB, proudly to say, from the great college Namidyango. Yes, that's a good question, and we see this a lot in practice. Yeah, we see so many group entities post or forward send invoices to the Ugandan subsidiaries for services they claim were received during the course of the year. Now, your question is specific. At what point should the Ugandan entity engage URA? Now, before you engage URA, like I've already indicated, there's need for you to understand in depth the origin of this transaction. In form of the documentation that you're required to keep. Okay, so before you engage the URA, first of all, say yes, I've received an invoice, and we have a related entity, say based in Mauritius, that wants me to pay 100,000. So the expectation, first of all, from the URA is that you have sufficient documentation to justify whatever figure is on that invoice. So if you do not have that sufficient documentation, then you've started trading on murky waters. Now, in instances where, yes, we have a Ugandan subsidiary that is not very sure about how they arrived at this particular price. Yes, the entity claims you have a transfer pricing policy, the price across the group, and this is what we intend to charge. Then it's very important for you to understand those particular methods used to arrive at that particular transfer price. Now, it's at that point that you're very sure that, yes, this invoice, the values posted thereon are consistent with the arm's length principle. Then, should you engage the Ghana Revenue Authority and say, yes, based on this, based on the documentation I have, that particular charge that the related entity is charging is at arm's length, and as such, I'm entitled to claim a deduction of whatever I'm paying to that entity. There's also need for you to sort of justify the cases that we've talked about, the Indian case. There has to be some sort of justification for that invoice. You know, we're moving away from the era of just receiving invoices. Now, if you've gone through a transfer pricing audit, they're going to ask you for those sort of deliverables, which sort of justify that particular invoice. It's not just, yes, they provided the management fee, but in terms of value addition, is there some sort of justification? If it's a service, was there some sort of report? If it's a product, what shows that that product actually came into the country? I don't know if that answers that question.
Thank you so much, Augustine, for the response. We have comments also from Mr. Kahima, which are very elaborative. I don't know whether Mr. Kahima, you're in position to talk. We could invite you and you orally speak, because I see you're typing, but there's still some time. We could, if you may.
Hello?
Mr. Kahima, you can
Yes, I
address.
can hear you loud and clear. Hello? Hello?
You can speak.
Yes,
We
I can hear you.
Yes,
I can
kindly. Yes. You were typing some comments.
Yes,
some
I have been
information.
typing comments. Hello? Can you hear me?
We can. Go right ahead.
Yes, I have been typing comments and enjoying the discussion going on. But one of my comments actually is to do with the advance price agreements. These are very, very, very complex agreements as well, because they are as complex as a post facto transfer pricing audit. Because you see, you have to make determinations about what Augustine was explaining. You must go through all of that for the URA to agree that yes, this is a proper transfer pricing price for a commodity or a service or any other thing we are going to do. That is what happens actually in advance price agreements. Because you see, you have to agree with the authority that whatever you're going to do is actually at arm's length, because the basis of transfer pricing is actually to ensure that everything you do, every transaction you make is at arm's length. Basically, that's what I wanted to say. And I saw another comment about contacting URA. It may not be necessary, because if the policy in place in the transfer pricing policy is in place in the group, there is no need, because everything you do is supposed to be arm's length. And of course, I noted the challenge Augustine had in practice about transactions being forced on to the subsidiaries in Uganda, for example. Yes, that is very, very common. Most times the finance officers in most of these subsidiaries do not know the purpose of the payment, do not know the basis of the payment. They just receive instructions to pay. And of course, because it is from head office, they have nothing they can do. They always effect the payments without regard to whether they are arm's length or not. And of course, eventually when the questions come, they find themselves not in position to answer to the queries that arise out of the payments they make in respect of those transactions. And I think basically that is it.
Yeah, thanks so much. Thanks so much, Mr. Kahima. I had to tap into your well of wisdom. And there is a comment also from Proskovia that a TP policy document is a living document that has to be reviewed and updated regularly as necessary. Yes, that's also a valid comment.
Yes, that's also valid.
Yes.
That's valid, yes.
Okay, thank you so much, Sam, for coming on short notice. You're welcome. Colleagues, that is it for our next session. I'm going to invite two people. I'm going to invite on my left, Diana Prida Praf, who will moderate the session that will be conducted by Hilda Bakanansa Walaga Chivuka. For that, Prida, the session is yours. I'm going to share the slides as you moderate.
Thank you, Tony. Good afternoon, participants. Welcome you to this afternoon session. As Tony has indicated, we invite Ms. Hilda Bakanasa Walaga, Manager, Prosecutions, Uganda Revenue Authority, Legal Services and Border Affairs Department. She'll be making a presentation on prosecution of tax offenses at the Anti-Corruption Court. She's a prosecutor, institute lawyer with a number of landmark precedents, her name. Welcome, Hilda, and we're ready to hear from you.
Thank you, Tony and Prida. Good afternoon, ladies and gentlemen. My role this afternoon is very simple. I'm simply going to share with you tax-related prosecutions at the Anti-Corruption Court. I hope this will be an interactive session where we'll get to hear from each other. Most of what I'm going to share is what we have experienced at the Anti-Corruption Court as a prosecution unit or section in the Uganda Revenue Authority. As you might see from your screens, I'm going to be speaking to you about the setup of the Anti-Corruption Division of the High Court, the objectives and rationale of the division, constitutionality of the division, URA's powers to prosecute tax offenses, and the jurisdiction of the division to handle tax offenses. If you could move on to the next slide, please. Starting with the setup at the division was set up administratively in 2008, July specifically, and it was called the Anti-Corruption Division of the High Court. It was set up to specialize in adjudication of corruption and corruption-related cases. And this setup was really deliberate because it was aimed to strengthen. Am I audible enough? Yeah, it was a deliberate setup to strengthen the adjudicatory mechanisms for fighting corruption. And what happened is that this administrative setup was by the principal judge. And as noted earlier, a specialized division for the High Court to adjudicate corruption cases. However, the Chief Justice formally established the Anti-Corruption Division. And I think so that I don't sound like a mouthful, I'll be calling it the SCD, Anti-Corruption Division of the High Court. And this was formally set up by the Chief Justice through the practice directions of the Anti-Corruption Division of 2009. The directions were made by the Chief Justice under his power in Article 133(1)(b) of the Constitution. The Chief Justice has power to issue orders and directions to the courts necessary for the proper and efficient administration of justice. So using this power as clothed on him by the Constitution, the division was set up to handle corruption-related cases. Moving on to the objective and rationale of the Anti-Corruption Division, the ACD, the objective is to provide for orderly mechanisms for the adjudication of corruption cases based on merit, speed, efficiency, and fairness of corruption cases. And when we talk of efficiency and fairness, here we're looking at timely and expeditious disposal of corruption and corruption-related cases, because these are cases that are entertained at the division. Now, unlike the other divisions of the High Court, the ACD is structured to have 2 chief magistrates and 4 magistrates. These are grade 1s. Currently, we have 1 chief magistrate, then there's a registrar, and then there's 4 magistrates. I think those are 3 magistrates. I beg your pardon. Now, constitutionally, magistrates are not supposed to be members of the High Court. But this was addressed by the Chief Justice designating these magistrates that are at the Anti-Corruption Division under Section 6 of the Magistrates Courts Act. And these are supervised by the Anti-Corruption Division itself. Now, the division is also headed by a judge, that is currently Justice Gidudu. And the head of the division is responsible for the overall supervision and administration and coordination of the division. So the magistrates that are operating at the Anti-Corruption Court are supervised by the head of the division. When we look at constitutionality of the Anti-Corruption Division, we can't speak of constitutionality without looking at the case of Davis. Sorry, the slides are reflecting David. It's supposed to be Davis Wesley to Singwire against the Attorney General. It was a constitutional appeal of 2016. This challenged the constitutionality of the High Court Anti-Corruption Division practice directions of 2009 that had been issued by the Chief Justice. They were issued on August 18th, 2009. The appeal sought for declarations that the directions been declared null and void for being unconstitutional, that the practice directions were inconsistent with the Constitution. However, the court found that they were not, and they did not in any way contravene the Constitution, which then effectively meant that the Anti-Corruption Division of the High Court was rightly in place and did not contravene any provisions of the Constitution, and that the Chief Justice was operating within his mandate when he set up this division of the High Court. When we move on to URA's powers to prosecute tax offenses, I think we are all aware that the Constitution grants prosecutory powers to the DPP, the Director of Public Prosecutions. But then the provision that provides as such in the Constitution also allows for the DPP to delegate these powers, save for one power, and that is the discontinuance of criminal proceedings. So when the DPP delegates these powers, he or she, the office bearer, issues prosecution licenses to the delegatees. And that is how we come in as URA, as the prosecutors under URA, as the prosecution unit, or whoever is prosecuting. The prosecutors under URA are licensed, and this is carried out on an annual basis. The licenses run for a period of 12 months, that's January to December, subject to renewal each year. That's at the discretion of the DPP. And what happens even when we're applying for these licenses, we will provide a report of our progress as far as the prosecutions for the previous period are concerned and how we have carried those on. And this should speak into our application for the renewal for the licenses. If our operations are found to be satisfactory, then we shall have the licenses renewed. Then the licenses are also, if I may mention, subject to expiry, lapse, or termination where employment with URA terminates. So they are attached to the employment with the licensee organization, if I may say so. Then moving on, besides being licensed by the DPP, we also have Section 228 of the East African Community Customs Management Act, which provides that a proper officer may appear and prosecute in any prosecution before a subordinate court for any offense under the East African Community Management Act. What this means is that a proper officer, and a proper officer is actually defined in the Act, also has the power to go ahead and prosecute for any offense that is under that Act, the East African Community Customs Management Act. But then it also qualifies it and says that this should be before a subordinate court. If you look at the subordinate courts there, these fall under the magistrates, the chief magistrate and downwards. And then if you also look at the penalties that are given for, or the punishments provided for in the East African Community Customs Management Act, vis-a-vis the guidelines or the parameters for sentencing and what kind of offenses or sentences can be passed at different levels, the Act, the East African Community Customs Management Act, goes ahead to qualify it under Section 220, subsection 1, where it allows for imposition of any fine or any sentence of imprisonment which may be imposed under the East African Community Customs Management Act. Essentially, this means that even as we are prosecuting under this Act, even as we are prosecuting under the subordinate courts, we still, the judicial officers are still clothed with the power to impose any final sentence, irrespective of their jurisdiction. Then when you look at also Section 65(2) of the Tax Procedures Code Act, it also provides that notwithstanding anything in any written law, a tax officer duly authorized in writing by the commissioner, and under this act, the commissioner is the Commissioner General, may conduct any prosecution for an offense under this act And for that purpose, the officer has all the powers of a public prosecutor appointed under Section 42. Section 42 of the Magistrates Courts Act is on institution of criminal proceedings, subject to the powers of the Director of Public Prosecutions. So you'll find that even when we are exercising our powers, even when URA prosecutors are exercising their powers, first we begin with the licensing. Then number two, we also have that the obligation that is given on us, put upon us by the East African Community Customs Management Act. And then you look at the Tax Procedures Code Act, also providing for the same. And the beauty about the Tax Procedures Code Act is that it's actually speaking to the appointment by the public, by the, the licensing or delegation by the Director of Public Prosecutions, and also the power or right given under Section 42 as a public prosecutor. And why we picked out these, or why these are the ones that are pulled out in the presentation, is that many a time, most of the prosecutions that we carry out, the offenses are really coming from these acts. Most of the time, not 100%, but 98% of the time, the offenses are coming from these two acts that are highlighted here. Then also, I must say that we have, and maybe we are going to see this in the next slide, we have had a few issues of where we derive our mandate from, but then also the jurisdiction, and then in as far as the East African Community Customs Management Act is concerned. Please take note of Section 253 that provides that this act, and that's the East African Community Customs Management Act, takes precedence of the partner state's law with respect to any matter to which its provisions relate, in as far as it is concerned with customs, in as far as it is concerned with the East African community. This act, the East African Community Customs Management Act, takes precedence. If we could move on to the jurisdiction of the ACD to handle tax offenses. When the practice directions were passed, and then we moved on to take our criminal prosecutions to the anti-corruption court, we faced a lot of challenges. Many a time when matters were being instituted or when they were coming up for first-time hearing, issues of jurisdiction always arose. And we have one such case that raised this issue, Johnny Manraguha versus Uganda. This is a 2016 case. And the question was whether the Anti-Corruption Division has jurisdiction to try offenses under the East African Community Customs Management Act, given that they are not mentioned in practice directions of the Anti-Corruption Division 2009. In this case, Justice Gidudu held that no injustice was suffered by the applicant in protesting his trial at the Anti-Corruption Court Division. Now, if you look at Section 225 of the East African Community Customs Management Act, it gives, and this is when we are speaking about jurisdiction specifically for criminal offenses, is that many a time the first issue that arises is where was the offense committed. So which then speaks into the place of trial, or the effects or the continuation of the offense, and all those rules that come into play. Now, Section 225 of the East African Community Customs Management Act, the place of trial is any place in which the person charged may be in custody for that offense, as if the offense had been committed in such a place. Essentially, what this means is that where the offender is in custody will be treated as the place where the offense was committed. Of course, now this if I were to look at it from our perspective, it comes into play for us and is an added advantage, because when it comes to customs offenses, which are governed under the East African Community Customs Management Act, they span borders. We're talking about the entire perimeter of the Ugandan territory, wherever we have presence and where we might not have presence, because if it's an offense, it might not necessarily go through the proper channels. For example, smuggling. So when you could find that an offense has taken place at one of the borders, let us say in the upper north, and then we have only realized or the person has been arrested while in the city center. So section 225 then helps us, comes into play, because it says that the place of trial will be the place where the person charged may be in custody. But then that notwithstanding, we also had we also have the practice directions, the designated magistrates who are attached to the anti-corruption division. They have territorial jurisdiction to try specified offenses committed anywhere within the geographical boundaries of Uganda. Now that means that even if the offense had been committed in Busia, Mbale, wherever, the designated magistrates at the anti-corruption division of the High Court are able to entertain these cases and hear them and adjudicate accordingly. Then because of the many cases that were coming up, because it became a practice that every matter that was being filed at the anti-corruption division of the High Court faced issues of questions of jurisdiction, at instigation, at first time hearing, at first time appearance. The issue of jurisdiction was always a must. So it became a habit or a culture that every time you are going to hear a matter, or you had a matter before the anti-corruption division of the High Court, you needed to be ready with submissions on jurisdiction. So we decided to make a case for it, because if we had to go through this, then it was clogging the speedy trial that we intended to have. Sometimes it was a delaying tactic. So we needed to be ready. We needed to find a lasting solution to the issue of jurisdiction. So we made a case for it and requested, put our case before the Chief Justice and requested that the practice directions are amended to clearly state on matters concerning jurisdiction as far as tax offenses were concerned. On matters concerning jurisdiction as far as tax collection, tax administration was concerned, and the regulations, implementation, and whatever to do with tax crime was concerned. And listening to the proposals that were put across, the discussions that were held, the directions were in 2019 amended. So now we have new directions. We had the initial direction setting up the division, and then we had an amendment in 2019 that catered for offenses arising from tax laws and any other laws and the regulations concerned with implementation, administration, and control of customs or collection of taxes, which meant that now we were properly, if I may say, for lack of a better word, before the anti-corruption court. So offenses arising from tax laws and any other laws and regulations concerned with implementation, administration, and control of customs or collection of taxes now fell under the ambit of the operations of the anti-corruption division. Because, and one of the cases we are putting across, or the reasons we're putting across, is that if the anti-corruption division was set up for only corruption and corruption-related offenses, then what happens where money that should be going to government, that should be collected as revenue, is being diverted for personal gain? Who is affected in this case? So the parties that be found it worthy that tax offenses are also accommodated in the anti-corruption court as falling under corruption and corruption-related offenses. And now this explains why 98% of the prosecutions for tax crime are carried out at the anti-corruption division of the High Court. I hope I have done some justice to the subject that was given to me for presentation. This is all I had for you. And like I had requested earlier on, I was hoping it's going to be an interactive session. So I'm eager to hear from you as well. Thank you very much.
Thank you very much, Hilda, for that insightful presentation. You have indeed done justice to the topic. You've highlighted, you've really addressed the issues of jurisdiction of the anti-corruption court, which was a sketchy subject for many practitioners, and the prosecution powers that are delegated to the URA prosecutors, enabling them to prosecute. Thank you very much. We have a few issues that have come through, questions and from the chat. Someone was asking, what are some of the benefits that you've gotten out of having a designated court for prosecution of tax matters? In this case, the Anti-Corruption Division.
Thank you very much, Prida. Some of the benefits and then what maybe strikes top of the list for me is when you have a centralized place, it is a little easier for and faster for people to understand your business, to understand, I'm trying to pick my words very carefully, so I'll just stick to understand your business. Because tax is a bit unique. It's if we are to be very honest with ourselves, even as legal practitioners, it's not one of those areas that you wake up and just dive into. You need to do a lot more research, a lot more reading, a lot more understanding. So when you're faced with these offenses, and much as they might seem like your regular criminal offenses, you need to understand the systems, you need to understand the workings, you need to understand the semantics, the technicalities and all those things. When you have one place like this, then when you carry out trainings and then when you have consistency in the cases, because I can tell you that on average, we have about 3 to 4 case files that are registered at the Anti-Corruption Court with every 2 to 3 days, which means that every day we might be putting in a new case. Then because of this consistency, then the judicial officers are able to appreciate the cases better, so they're able to understand them even as we are putting our witnesses across. And this is not to buy into the judiciary, but when you have the same officers and then they're able to look through this, so you'll find that we actually have lesser appeals, not because we are very comfortable with the outcomes, but because we've realized that they have learned our business. We have cut down on the cost that we would have incurred for training, on tax training, if we were to span the entire territory of Uganda and the judicial officers across. And even then, we have had very good judgments that have come out that have contributed to the jurisprudence, criminal jurisprudence of the country. So and then also the location itself has been very beneficial to us, because the legal department, as it is located in the central business district. So we have cut back on transport costs, fuel, taxpayers' money, as such, trying to pursue these cases up country and things like that. And then also the security as well. We used to have issues of because when you have these habitual smugglers, you'll find that they're operating in a region, and maybe these are the people who have also helped so many people in the region, would have insecurity that when would travel to prosecute these cases in those upcountry courts, sometimes you find that the people in the region are waiting for you. Who is this? Who is after our person? Who is after our person? Who is educating our children? But the activities from which they're earning to be able to take care of these people in these societies are actually illegal. So then you have to watch out for your own security. We had previously went to places where we were denied accommodation simply because we're coming from and from their perspective, from an angle that we're after their people who are, taking care of them and things like that. So it's been a lot of benefits for us, not only on the jurisprudence angle, but also the security, then the costs that are involved. We've really benefited from having one central place where we can prosecute our matters.
Thank you very much, Hilda. You indeed raise a pertinent issue of speciality. We all agree that tax is indeed a complicated issue, and the specialization of the court, I think, does help in rendering those landmark decisions that you've mentioned. And I think we've seen that develop through the years from the different issues, especially in the application of the East African Community Customs Management Act, which is complicated on its own. And yeah, so that's a plus for the court there. building upon that, the issue of specialization, what are some of those offenses, key offenses that you've seen as being more common or being more prosecuted at the court?
Some of the most common offenses, and maybe before I go into that, is that I should note that, okay, the most common ones are coming from the East African Community Customs Management Act. And when you look at the nature of those offenses, is that most of them are strict liability offenses. And one of the most common is possession. And we're talking about possession of uncustomed goods. These are goods on which duty has not been paid. We're talking about possession of prohibited items. Most common of that being the bleaching creams, the Carolite, and so forth. Then we are talking about possession of restricted items. These are those for which you need to have a certain permission to be able to deal in those items. For example, the supermarket cigarettes. Those are really very common, and this is because they tend to give a quick return. For example, look at Carolite or the bleaching creams. I inquired, I went further and inquired when I realized that we're having so many of those cases. I inquired and was like, are they really that, the market for them, is it that wide? And I was surprised to find that cosmetics actually do really well on the market, especially the bleaching creams. So we have many of those coming through. We have seasons when you have a lot of phones coming through. For example, every time there are releases of new phones, you'll find that the type that is being phased out or the type that is before the release, you have many of those coming through, and they're not even going to just come through the borders. They're going to also come through the airports and things like that. And then we also have items really that are profitable on the market are common in these offenses that we find: textiles, secondhand clothing, shoes. Those are very, very common. But what you'll find is that most times it is possession as the offense that is coming through mostly, because people feel like they can just walk across the borders and put these items on themselves, get themselves covered in these items, and then walk through as a normal person just crossing the border. And you know, our borders are very porous, and we cannot, I don't think we have the manpower to be able to deploy security or deploy security at every point of the border. So we have so many people walking across. Someone will just walk across maybe 3 to 4 times a day. And every time that they have crossed the border, they have crossed that line, they're actually carrying something on themselves. Every time they have a handbag and they have crossed, they're actually carrying something on themselves. So we have a lot of possession coming through, as opposed to the ones that require declarations, paperwork that is going to be looked at, and maybe containers that are going to be scanned, and then we are going to be able to see what is inside. Prida, does that help?
Thank you very much, Hilda, for that elaborate answer. Indeed, yeah, it is very good that you've mentioned the issue of the cosmetics. We always get the feedback that we are always impounding cosmetics. Why? And I think the other overriding issue is that other than the tax factor involved, is also the protection of the health of the Ugandans, which is one of our mandates. So it's good that you've highlighted that, and that cigarettes as well. Another question that has come through from Gloria is, they have issues surrounding bail. They've seen that the practice in other courts, bail is a touchy subject, and although there is jurisprudence on the matter, it's still in practice, bail can be a challenge. So the question is, what are the conditions for grant of bail at the SCD in specific?
Okay, for grant of bail at the SCD, I don't know why. As a prosecutor, I have issues with bail at the SCD, but I've learned to make my peace and work with the regulations. They're called the practice regulations of the Anti-Corruption Court. They're fairly new, and they have an aspect concerning bail, But before we even go into those, the requirements for bail are the same across all other courts. They are the same across whichever court that you're appearing before. You'll need documentation pertaining to the sureties. First, you'll need sureties, obviously. Then you'll need paperwork to speak to who these people are. And usually we have those through the LC letters. And then now that every Ugandan is expected to have a national ID, that also helps a lot. You'll need a copy of your national ID. What I have seen at the anti-corruption court is that you need to come with the original copy. And this is, I think, because very many people are coming up with forged copies or duplicate copies. So you need to come to have a copy of your national ID, the original copy. And then what has come out as on top of the usual requirements, you should have the surety should have some degree of control over the person they're standing for, so that they are able to advise them. They should be educated on their responsibilities as sureties. The other thing, the one thing that has come through at the anti-corruption court and that I find peculiar for the courts is that because they are dealing with corruption-related offenses, and when you speak of corruption-related, when you speak of tax offenses, you're speaking of money, you're speaking of liquidity or of some sort or at certain level. What they have added in their practice guidelines is that as a requirement, a surety should be able to show the court that they are in a position where they are earning, gainfully employed or gainfully carrying on a business where they are earning, that push comes to shove where the accused person disappears and you're called upon to present them or produce them and you fail, then you're able to meet the obligation that was imposed on you as a non-cash payment. That is the bond fee. So that is the new thing or the peculiar thing about the anti-corruption division, that they want you to show them as a surety that you're gainfully employed and you're able, not only employed, really carrying on business of some sort, and you're able to meet the bond in case the accused person disappears. That is the only addition as far as bail is concerned.
Thank you, Hilda. As a parting shot, what advice or takeaway advice would you have for practitioners, especially the vice counsel who practice at the SAD?
My takeaway for practitioners is that please embrace plea bargain. Embrace plea bargain, because many a time we have seen that practitioners come in and their main interest is bail, but the case does not stop at bail. And like I mentioned earlier, that many of the offenses, the tax offenses that we have, they are mostly, if not all, strict liability. So take time and look at your client's file, look at the disclosure that has been given to you from the state side, and then weigh. Do not look at it as long as they have secured their freedom at the bail level, then everything else is going to be a smooth run. Because I'll also tell you one thing, our cases are not the kinds of cases, when it hits 2 years in the system, it is backlog. So it's red flag. What that means is that we have a conclusion rate of cases of 8 months to 1 year, tops, really. That is if we are really stretching it. So it's not one of those cases where you're going to buy yourself time by waiting it out because you think that it's going to carry on for a couple of years while this person moves on and then things like that. No, embrace plea bargain. It is for the good of your client as well as beneficial for the prosecution as well. And it's not a do or die, really, if I may say that. It is you looking at your client's case, looking at the disclosure, and then taking that decision that, when I look at this from the prosecution side, am I able to determine that this is actually a bad case, and it being strict liability, what is my comeback for a defense? And will it pass the test of time? Look at the precedents that have been set from the court. Good enough they're in one place so you can access them. Look at them and then take that decision for the benefit of your client and maybe for the country as well. Thank you.
I thought we were done, but another question has come in, and this one is about ECMIS. The question is how efficient, or if what your experience has been with the use of ECMIS at the Anti-Corruption Court.
Personally, I find ECMIS is very, very efficient. We have a shorter period now when we request for records, and like my parting remarks were for practitioners. There used to be a bit of a lapse of time for, say, where someone desires to appeal a decision that has been taken, and then you have to wait out for typing of the record, and then, quality assuring that it's actually a reflection of what took place. Now this is happening in real time. It's actually happening faster than you would have desired, you as the appellant, if I may say so. And then when it comes to registration of case files, we no longer have issues of move with the file, the physical file, make sure you're moving with it to court, is so and so around, I have to run around here. No, it's actually all happening at our in the comfort of our offices. So what happens is, for us, the moment a case file is received and perused and it is found to be good to go, the charge sheet is sanctioned, there and then it is registered and uploaded on the ECMIS system. And then as you're uploading, you're also in touch with the investigating officer who is proceeding to the court premises to follow up on the allocation. And by the time they get there, the case file is actually allocated. And what is left is for the prosecutor to show up at the court and then proceed with the hearing or the plea taking or the bail application and things like that. So I found the system to really, really be efficient, that it's helping with timely registration, timely allocation, timely disposal, timely extraction of whatever you want to be extracted. For example, at least I've seen that the judicial officers have taken it on seriously. So even those who are not tech savvy, they have found a way of quickly adhering or quickly, getting with the program, and then they're able to offer this service in real time, which is a good thing for all the parties that are involved.
Thank you very much, Hilda. And that was a very insightful presentation and very lively discussion. Thank you, participants, for the questions. It's really been engaging. With that said, this is our last discussion for the day. Yeah. And thank you for attending, and we look forward to more fruitful deliberations and more engagements tomorrow. Thank you very much.